Hello, chat. Good evening. Oh, can you guys hear me? Okay, hold on. There we go. Good evening, chat. Hello. Hope you guys are doing well. I've got Clyde. He's all alone tonight. 2.0 abandoned us. No, she had to go out of town. So it's just us tonight, and Clyde's all like panicking. He's like, "Where, fat man? What do I do?" But anyways, chat, hope you guys are doing well. Wow, I sound really, really loud. Jeez. Real quick, EW's is late and gay. Oof. The only gay person here is the person who was incorrect on that. So, and it ain't me. It ain't me. So, welcome to the show, guys. Welcome to the show. We're going to discuss, if you guys are new, my name's Sean. I'm a potential criminal. I'm an attorney in the Cleveland, Ohio area. And tonight we're going to talk about oral arguments that were had today, which were humorous, to say the least. Humorous and very interesting on where things are going to go regarding the Voting Rights Act. And some of you might say, wait, that thing in 1965? Yeah, that is still, that is still lawful law, as a sovereign citizen may say. And this is Clyde. He's the biggest and, best good boy ever. Won't need no shot collar for him. No. No, he's too nervous. He won't even. He's like, I'm too nervous. Your scritches don't help, fat man. Hi, Bubba. He's waiting for 2.0 to come home. He's like, you said her name. Well, I'm going to set you down, okay, Bubba? Don't worry, chat. We'll see him probably like a million times tonight. We'll probably see him a million times tonight. So, all right, guys. Anyways, welcome. And yeah, I'm still dressed up from court today because I didn't have time to change. I've just been running around everywhere. So let's take a look here. Bullcut Nationalist says, I didn't know Ohio representatives were so base. Dave Taylor, that's a guy down south. His staffer had a friendship windmill prominently displayed on his cubicle wall. Well, based, but yeah, that's not. I have a different Dave. When I thought you said that, I'm like, are you sure you don't mean Dave Joyce? Because that's my congressman. But no, there's a Dave. There's a Dave Taylor. I just, I'd expect that out of up in my area. EDW Raptor for $5 for a suspender snap. I guess it's the one time I will dance like a monkey, but there you go. And Fair Frozen 55 says, remember, as authorized voice of black folks, Ketanji Brown Jackson called them all lazy, good for nothing. Yeah, we're gonna get to all this here. We're gonna get to all this. This is it got interesting. It got very interesting. And Amateur Iconoclast real quick, because checking in from Clovis, New Mexico. Home of the Clovis people. That when you go back to our archaeology chat, that is where we found some of the first Stone Age things. And that depends. If you ask Graham Hancock, that's not true. That's not true. But that's where you hear the term Clovis people. That's why. And he says, hopefully one of the Ospreys from Cannon Air Force Base doesn't crash land on me. Yes, that would always be the nerve for me. Getting in an Osprey and hoping it doesn't crash. So let's get going here, chat. To get going, we are going to bring on. We got a guest with us tonight. We have Snarf Magoo saying hello. Well, hello to you too. Booch is saying black sub-Saharans invented everything. Okay, well, yes, I guess. Pseudo Snarfman number 21 says going to do a little Chili's too. I don't know what you mean. But thank you for being here. 21 months. So it always sucks when I don't get the joke. Dolly says, Kurt, sure hope so. We'll get to him. And then Meme says, is it the train stream? No, but we do have a train whistle just for you, Meme. I'll bring you on Friday night. We'll probably do the train stuff, but I'll just for you though. All right, let's get started though. It's been 5 minutes. We're gonna bring on our guest, fellow creator and also practicing attorney, Kurt on civil law. How you doing, Kurt?
I'm doing reasonably well. How are you doing?
Well, it's better than unreasonably well. How are you?
Also, Supreme Court guru.
Yes, and man who's going to be soon going to be doing 3 wheels on each side as he's doing his workouts. So I heard that.
That is the
Congrats.
working plan. Yeah, I'm
Yeah.
pretty much there on squat and deadlift, but I
Mhm.
have about 40 pounds to go on bench,
That's
and
not.
90 days to do it. So we'll see
That
what we
means
can do.
that means you're knocking out 270. Well, there you go. I mean, when you say when you say it
265,
like
but yeah.
that, yeah. There you go. There you go. So, anyways, good to see you, Kurt. Did you listen to any of the clips that were out there today?
I listened to a few of them on Forbes, I think, Forbes channel.
Yeah, I saw a couple on Twitter as I was going in and out of things, and oh my God, there are some obnoxious things that are going on there. And real quick, I guess, because we need to go back to this, where we start with this whole thing, guys, if you're not familiar with it, it's a case of Louisiana v. Callais, and it deals with the Voting Rights Act, specifically Section 2 of the Voting Rights Act. And, the easiest way to look at this is we're going to use the civil division of the DOJ.
Mm-hmm.
And they talk about the Voting Rights Act. That's one of the things they have to do in the Civil Rights Division. And so the Voting Rights Act, it prohibits practices or procedures that discriminate on the basis of race, color, or membership in one of the language minority groups identified in Section 4F2 of the Act. Now, they go after things here, and there were a lot of problems trying to get, Black people on the right to vote. As things went on and went on and went on, you ended up with, and this is why, if you guys have noticed, districts and congressional districts get challenged for racial gerrymandering. That becomes issues. And for example, there's the famous example in North Carolina where the congressional district traced up the side of a highway for 20 miles because they were trying to adhere to things in that way. So ultimately what Section 2 does, in the 80s, there were pushes for majority minority districts. Now, what does that mean? Well, there have to be some districts where the majority representation is for minorities, and which translation means Black folks. I mean, that's obviously what the Voting Rights Act does. Now, eventually in the future, we're going to get to issues of, Hispanics, Latinos, whatever it's going to be out there. That is part of it. Would you say that's a pretty good kind of quick rundown on that?
Yeah, but the other thing that is the other way of phrasing that exact same thing, it means that you're packing certain districts.
Yes.
Because there's packing and then there's cracking, which is just the opposite of that. So when you pack a district, you put more of what's in there than otherwise would be, your race of choice being the typical. And then cracking is just the reverse of that. You crack it by taking it out of the district. Well, the thing is, of course, that ultimately it's zero sum, because ultimately you're dividing the state, and so you're constrained by those boundaries. So to pack a district inherently means you're cracking another district, if not more than one. And packing districts for the purpose of racial discrimination is one of the things that people were suing for a long time, because they were of the opinion that, well, the idea at least was, we'll put all the black voters in one district, and then that'll be their district, and then they won't be able to vote anywhere else. And then the people who are saying, oh, that's bad, say, well, to solve that problem, what we're going to do is we're going to stuff all the Black people into one district.
Yes.
So they have voting back. It's like, wait a second, is this the same thing?
Yes. And which then gets you to the state of Louisiana, because obviously with the name Louisiana, we're talking about the state of Louisiana.
Yep.
And, this is the hometown of Ag, biochemist, and our EDW Raptor. They're both great sons of Louisiana. And you guys can see here, as you hear Laney howling, there are 6 districts in Louisiana. That's the other part of the zero-sum game. You don't get more than what you have. So you have 6 districts in Louisiana. You have 1, 2, 3, 4, 5, and 6. And yes, number 4, this is where Mike Johnson, Speaker of the House, is from. This is his district. And spoiler alert, there are 2 Black districts in Louisiana. And they are, if you live in Louisiana or know about the area, obviously Shreveport and Bosler City, all the way down and around, up to Baton Rouge. And then you have 2nd district, which covers New Orleans and comes down and around and around. And this is basically, yes, we had to corral all the Black folk and give them their own little enclave and wall them off. Now, what had happened previously is this district here, number 6, they had pulled from these other. So, and the way it works is these two are Democrat districts. and you have 4 Republicans in the House right now. What had happened was the 6th district had been broken up between the 3rd, the 1st, the 4th, and the 5th. And they tried to water it down, and people challenged that. And they said, wait, that's racist. You can't do that. So it ended up getting restored to the 6th and the 2nd. And then as it's so eloquently put it, I think SCOTUS blog, it's so funny. They're so upset about this whole thing. Non-minority voters filed a lawsuit saying this is not fair. You're now districting on race.
Right.
And
which is the very thing that Section 2 of the Act prohibits.
Yes.
You're not allowed to do that either way.
Yes. And a group of individuals, there's an article I read, they identified as non-African American, which is like, well, I doubt it's the Asians voting in Louisiana. They challenged this whole thing and says this is bullshit. You can't do this. You can't do it. You can't. Racism is racism, like we've heard before. There was a case a while back with the for employment discrimination, where if you're a white person, you had extra steps you had to do. I don't know if you heard about this case a while ago. That some circuits had included, if you were white, you had to show an intentional action, like you had an extra step to prove discrimination. And Supreme Court's like, no, that's not fair because everybody has to have the same rules. We don't have different laws for different people.
Right.
So the Supreme Court has said, well, isn't just discrimination? Yes. And that is where we're at now with this, is this looks pretty discriminatory. And you see this in other states, though. And, for example, if you guys look at your own state, you can find these things. Ohio is similar. Ohio has this right here is the 11th district. This is basically Cleveland. That's majority black. You have the 3rd district. That's Columbus. That's majority black. And then you have the 13th. And this is majority black. Now, there are other Democrats, like the guy in, I think it's the guy in the 1st. He's a Democrat. But then everybody else, it's, white folks everywhere else. Also, this lady up here, Marcy Kaptur, she's a Democrat. I fucking hate her. Bitch wouldn't let me go to West Point. But anyways, there you go. Those are, and it's, the way it works, you have a couple of Democrat strongholds, but then the rest of it is, it's not as bad as in Louisiana, because this map of Louisiana, it's like, whoo, that is very gerrymandered, but hey, everybody wants their little place. So that's what they get.
Well, it depends. Again, if your goal is to have majority districts, because they're a minority, you have to get all the people in the minority into the majority, which means you would necessarily have to draw lines that are going to look weird to accomplish the objective.
Yes.
Right? So you're going to wind up with something that looks weird because you're trying to skew for it. So it's like, well, what do you want?
Yes. And this was floating around Twitter, and I don't know if this is correct, but this makes sense. If you get rid of the Voting Rights Act, as far as gerrymandering on race, the South changes quite a bit. That is a very different racial breakup and very much different demographic breakup. Dagmore says, I was too fat for West Point. Not when I was in high school, buddy. Not when I was in high school. Remember, high school was almost 25 years ago for me.
Personally, I think that we should just sort of solve this and require the districts to be maximally compact. And then there's basically much fewer ways of drawing that. So districts have to mean a couple things. They have to be contiguous, which means they can't have enclaves and exclaves. So they can't have like a part of the district existing in another district or vice versa.
And that's why you have these little goofy. So
they have to be completely whole. They have to have equal population within, I forget, some margin of error, but basically essentially even.
Pretty close.
And the other thing is they have to be compact. Now, the most compact shape you could possibly have is a circle. So the more circle-like, the better.
Yeah, the problem is a lot of these states aren't circular.
I understand that. But you could do it mathematically to have the most compact shape. You could, and of course there are any number of websites where you can go see what that would look like.
But they're going to say math is. But what about math being racist, Kurt?
Math is not racist.
Yes, it is.
It is in fact not racist. It is the opposite of racist.
I don't know, man. That's not what I've been told. That's not what I've been told.
Okay.
So, it's absolutely racist.
Well, for it to be racist, it would have to be prejudiced, which how?
It is. Have you ever read the FBI crime stats? They're very prejudiced, and those are numbers.
That doesn't, even if that were true, that doesn't mean the math itself is racist.
I don't know, man. I don't know. That's not what I've been told. So,
even if the numbers were skewed, the numbers themselves would not be. Yes. That's not.
I know.
It's like saying the number 31,000 is racist. How?
It probably is. You know, it was probably a white man who was able to come up with that while his slaves were working in the fields. I'm sure that's how he had time to develop such a number that high. You know, 31,000, that's the number of poor little black kids who don't get to graduate high school on time.
Well, it was mostly the Arabs around the 6th century, as memory serves, but, you know, there is a reason they call them Arabic numbers.
Yes. Tech Guy South says the number 1488, yes. Although, remember, chat, simplify your fractions at 7/44. Come on now. Come on now. So, also, guys, that is not that's not Clyde. That is Lainey barking, and she's very sad that 2.0 is not here. I may have to close the door in a minute if she won't chill. Because she's sitting there thinking, like, every time she hears something, oh my God, it's her. And it's like, no, it's not her. All right, guys. So with that said, this has gone on, and the future this case may sound boring, aside from changing gerrymandering, but it also affects. There's another case coming up this term. It's called Turtle Mountain Band versus Howe, and it's about the 8th Circuit saying that the government can only bring challenges under the Voting Rights Act. So there are a lot of issues that that doesn't allow people to bring. That doesn't even
begin to make sense. Why would only the government be allowed to bring challenges under the Voting Rights Act?
You can only the 8th Circuit only ruled the U.S. government, not private entities, can sue to do Section 2 of the Voting Rights Act.
Okay.
Which, hey, that's what the 8th Circuit said. So there's a lot. There's a lot of things that are brewing right now. But anyways, let's move on. We've got C-SPAN ready to go, and they are. We've got
my excitement cannot be contained.
Yes. All right, chat. I've got this up as loud as I can get it, so you're gonna have to, if you need me to turn it up more with the volume, let me know. So, anyways, here we go.
Louisiana's congressional redistricting.
This is going to be a little delayed, and this is going to be very delayed. I don't know how to fix that, chat. You're just going to have to suffer.
I need more volume than that, please.
Okay, let me try to turn it up some more. Let's see here.
Map is an illegal racial gerrymander. This is live coverage here on C-SPAN 3.
Noted that under certain circumstances, it has authorized race-based districting to remedy state districting maps that violate Section 2. Louisiana affirmed findings that, 6 appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58% declining white electorate entrenched control over 83% of the congressional districts. Louisiana's creation of a district to remedy that discrimination and to ensure that Black Louisianans have an equal opportunity to participate in the process is constitutional. Precedent from Brooks to Milligan, from Ex parte Virginia to SFFA confirm that. And 3 facts guard against indefinite use of race. First, not all Section 2 remedies center race. Second, when racialized politics and residential segregation wane, so will the ability to satisfy jingles. Third,
when racism ends. Oh, okay. I'll keep.
Yes, when we fix it. When will we fix it? I'll let you know. Well, like that's the problem here. What's the measurement? Like when there's no more racism? Like
yeah, I like it. I like it's like not all Section 2 things are race-based. I'm like, well, technically, I suppose, but 99%.
I almost wanted to ask her, yeah, which things aren't? I assume you can tell me the distinction there. But also, chat, I'm not going to lie. 14 days, 10 hours, 6 minutes. This was also like hours and hours ago. So, but that's great. Yeah,
It
you'll
was
love
at
to
10
see it.
a.m. this morning.
Yes. Yes. So it's even farther along.
Almost every redistricting map is replaced decennially. My opponent's
Yeah.
late-breaking
Because that's what the census is. Thanks.
Yes, Chet. And if you didn't know, for those of you in Rio Linda, yes, the congressional maps are redrawn based on every census.
Yeah. I like how she said almost all, because there are a few congressional district maps that are not redrawn because the map is just the state.
Yes.
Yeah.
Yes. Yes, in Wyoming, they
Alaska's
don't have
map
to
doesn't require a lot of gerrymandering. It's
neither does Wyoming's.
yeah, Wyoming. Yeah, exactly. Yeah.
So let's keep going here.
and recordless facial and as-applied challenges seek a staggering reversal of precedent that would throw maps across the country into chaos. If SB 8 is unsatisfactory, the proper recourse is to remand and adopt one of the many alternative maps that address the Section 2 violation and satisfy the Constitution. As this court noted in Milligan, Congress is undoubtedly aware of Section 2 precedent and can change it if it likes. But unless and until it does, statutory stare decisis counsels staying the course. I welcome your questions.
Counsel, what was the finding or the holding in Robinson, and what role does it play in the SB 8 map creation?
The finding in Robinson was that there was a
You guys know when Uncle Clarence gets off the bench and starts talking. Ooh, here we go. I'm sure
He's pretty active these days since they changed the rules a couple years back.
Yeah, I know, but he's like, he's like, is the official black man on this panel. Let me start asking questions.
Mm-hmm.
Here we go. Let's see how this goes, guys.
likelihood of succeeding in a Section 2 claim proving that the state of Louisiana violated Section 2 by packing and cracking black voters. So there was a Section 2 liability finding under a preliminary injunction, and there was an ordering of a new map to be drawn.
What is the status of that case now?
Robinson is concluded, and there's now, as we know, the challenge in Callais that suggests that their map that was created out of Robinson, SB 8, is a racial gerrymander, and that's why we're here today.
So SB 8 was the remedy for the Robinson case. I thought that was a preliminary injunction.
Yes, there was a preliminary injunction indicating that we were likely to succeed if we continued to pursue a claim. This is after a 5-day hearing with 21 witnesses and a robust record. So the court found, based on that evidence, that we were likely to succeed on liability, and ultimately instructed the state of Louisiana to draw a correct and constitutional map.
But there was never a full merits determination.
That's correct.
SB 8 was entirely separate, though, from that litigation.
SB 8 came after the litigation. It was in response to the court's order to create an opportunity district and a second map that would cure the Section 2 violation.
But did the court order this particular map?
No, the court gave the state of Louisiana an opportunity, as this court has suggested it do. It gave it broad discretion, gave it wide latitude to create a map that it felt was satisfactory, and ultimately that is the map that was in effect and elected a congressional delegation in 2022.
Counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given and considered Alabama's application of its approach to the evidence and all that under that precedent. Is that your understanding as well?
That's correct. In fact, the case was stayed because this court held that case in abeyance until it decided Milligan, because it understood Milligan to be important to understanding the case in Robinson.
But it was a case in which we were considering Alabama's particular challenge based on its what turned out to be an improper evidentiary showing.
I'm sorry.
In other words, we were looking at Alabama's suggestion that how to apply its body of evidence or which evidentiary considerations we should take into account under the existing precedent.
That's correct.
Thank you.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held or what we held in that case is relevant to what we're doing here today.
Allen versus Milligan is a nearly identical case. There was a similar challenge where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama,
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
Can I ask you a question about what Milligan means? In Milligan, the court said that the first Jingles precondition is that, quote, the minority group must be sufficiently large to constitute a majority in a reasonably configured district. And then it went on to say that a district will be considered reasonably configured if it comports with traditional districting criteria. Would you agree that incumbent protection is one of those?
Incumbent protection has been considered a traditional districting.
So notice, as long as we do it by traditional means, how can it be racist?
Well, I think the right answer here is the same answer you would use for Title VII, right? When you're talking about employment discrimination on the basis of race. If you're doing it for reasons other than race, it's fine. If race is a reason you're doing it, it's not fine.
Yes.
So the question is, what is your motivation for doing it? So if in the employment context, if you're doing it because, you need to lose staff because you have too many people or, disciplinary issues or whatever, you can do that, but you can't do it if one of your reasons is race.
Yes. And remember, though, you have to worry about the issue of disparate impact. And that's the issue, guys, we talked about this before with employment issues. If your program and your concepts and policy are racially neutral and they're neutral on its face, they're applied neutrally, but they end up with a discriminatory impact on a minority group, even if you didn't intend for it, that is still considered discrimination.
It can be.
Yes, it can be. And their argument is, well, even if you do everything traditionally and you aren't saying it's not about race, we can cry and say it is about race. And that's her argument here, is saying that basically she's going to say everything is racist as we get going here. But that's kind of where we are. Sean is racist.
Disparate impact is more often
you must be new. David.
Disparate impact is more often used as a factor to show that motivation was racial rather than like an end unto itself.
Yes, but they argue that the end it led to that impact. It led to that end. So, and that, but anyways, yes, everything is racist. Yes, the Ornithius are keys and gambit. Yes. So here we go. We're going to
If everything is racist, nothing is racist because the word you can't.
Yes, I agree. I agree.
It's like highlighting everything. When you highlight everything, you highlight nothing.
That is very true. Very true.
Criteria. However, we know that protecting an incumbent, like core retention, can continue to perpetuate discrimination, and it does not trump the anti-discrimination.
All right.
Also, Chad, I'm not going to lie. I didn't realize I forgot it was 2.5 hours long. We gotta kind of get on our horse and go here.
If incumbent protection is a
What, you're here for a good time, not a long time? You get somewhere to be?
Then under Lucho, isn't seeking partisan advantage
Put on that
also
1.25,
an
bitch.
objective that a legislature may
just a little faster.
legitimately seek?
Not if it comes at the cost of the equal protection principle and the 15th Amendment's prohibition on race discrimination in voting. It is not.
Well, if the objective is simply to maximize the number of representatives of a particular party, that's seeking a partisan advantage. It is not seeking a racial advantage. Isn't that right?
Well, if race is used as a means to seek the partisan advantage, then that is
Oh,
unconstitutional.
sure.
There's no
If race is used as a proxy for partisan affiliation. Let me ask you a related question about block voting, which is the second, figures in the second and third Gingell's precondition. If registered Democrats overwhelmingly vote for Democratic candidates, regardless of the candidate's race, is that block voting?
If you're looking at it simply from a party perspective, no, we don't judge block voting based.
This happens more than once, chat.
Yeah, nice.
We have a bunch of white men. It's a bunch of white men just asking questions.
Well, it's a bunch of white men looking for intellectual consistency.
Yes. Yes, and if you guys need to hear that again, we're going to rewind it.
I've heard logic is racist. I've heard that before.
Yes. But remember, this is there's going to be a lot of there's going to be a lot of this issue coming up right now. This is kind of the beginning and the end for this woman.
Or partisan affiliation. Let me ask you a related question about block voting, which is the second, figures in the second and third Gingell's precondition. If registered Democrats overwhelmingly vote for Democratic candidates, regardless of the candidate's race, is that block voting?
If you're looking at it simply from a party perspective, no, we don't judge block voting based on party. We judge it based on race. Racially polarized voting is measuring racial performance and voting behavior.
And likewise, if registered Republicans overwhelmingly vote for Republican candidates, that's not block voting.
That's not how we measure voting. We measure voting based on race for purposes of Section 2 because the Constitution forbids race discrimination in voting, not party discrimination.
All right, so if it happens to be that people of one race or another race overwhelmingly prefer one of the political parties, does that transform the situation into racial voting, or is it still just partisan voting?
No,
Once again, I can't wait to hear her answer. Yes.
She
don't
can't
need to
win.
ask her.
That's the problem. She
Yes.
can't win. If
No,
she's
she
honest,
can't.
it blows up her case.
Yes. Yes.
And if she says the other way, then she's not honest about it.
Yes. James says, suffer, bish. Yeah. And then real quick, EDW Raptor for 10 subs. Thank you, EDW. And real quick, we get no woo. You guys have earned that. Maybe November 15 months. Thanks for running 15 months. Well, I do what I can. Hexy says for $2, I want my district drawn for whites. Well, you may get your wish.
Yeah, well, I mean, they're kind of doing that already because,
Yes.
again, by putting all the minorities
Yes.
in one district, you're necessarily making the other
Yes.
districts more white. I mean, this
Yes.
is zero sum. They do realize this at the end.
Yes,
right?
when you ghettoize the people, it makes it clean. The streets are cleaner. Let's go, Brandon, for 20 months.
I
Thank
didn't
you,
say
Brandon.
any of those things.
Yeah, well, I'm just saying it does. Well, you know, we want them to be represented, so we're going to turn them into a ghetto, and it's like it's a voting ghetto. Yeah. I mean, that's what you're doing. You're doing that. It's a concentration.
I suppose
Normally
in so much as the ghetto is an ethnic neighborhood, then I guess that's true.
Yeah. You're ghettoizing the votes. And I mean...
The word ghetto is Italian.
Yes, it is.
Are Italians white?
Depends who you ask. And depends which part of Italy you're talking about. North, definitely, but depends on... If you ask in the South, there's the idea that they were left out in the sun a little too long. Myself included. But Brandon, thank you for bringing 21. Says, map is gay enough for this channel. Bob for 2 Australian Dowderly Doodle says, this assumes all black people vote the same way. She's going to have to defend that position. That's actually going to come up here. I don't want to spoil it too much. And then Alaskan M, been a member for 4 months, says, love when Kurt joins. So, just wanted you to know. So, yes, sun-dried Guidos, yes. Persians are whiter than Italians. I will fucking fight you for that, sir. How dare you? So, but let's keep going.
Look at how different races of voters vote and whether they vote in a way that is polarized. And the Jingles test requires us to look not only at that, but a number of other features as part of the totality of the circumstances test that suggest that race is playing a role to contaminate the electoral process and submerge minority votes in a way that violates the Constitution. So party cannot explain away a racially polarized circumstance unless we look at the totality of the circumstances. And I will say, in Robinson, for example, the court entertained testimony along those lines, as it did in Milligan, and found that it wasn't credible, that the extreme racially polarized voting that we have in the state of Louisiana cannot be explained away by party. We're talking about racially polarized voting that is above 84%, which is more than what this court found in Thornburg versus Jingles in 1986, and the numbers were 70%.
That could be easily analyzed by statistics to see whether whether white Democrats vote for black Democratic candidates at a lower rate than they do for white Democratic candidates, whether white Republicans vote for black Republican candidates at a lower rate than they do for white candidates. It's easy to isolate race from that to see whether there really is racially polarized voting as opposed to partisan polarized voting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 25 of its brief that the court should hold that plaintiff's illustrative district cannot disregard the state's political objectives, and goes on to say Section 2 plaintiffs cannot claim a lack of equal openness where politics rather than race is the likely reason for the state's refusal to create a majority-minority district?
Yes, that suggestion would swallow Section 2 whole. As I said, party cannot trump the responsibility of states to ensure that all voters have an equally open electoral process. The fact that black voters may correlate with voting Democrat or white voters may correlate with voting Republican does not deny the fact that there is racially polarized voting, and the totality of the circumstances, including the inability to elect black candidates in Louisiana on a statewide basis for a number of offices. There's never been a black person in Louisiana elected statewide, is additional indicia that race is playing an outside.
Louisiana literally had a governor who's Indian, Bobby Jindal. Mm-hmm. Like black folks can't run. It's like an Indian guy, like a first gen. Like I don't even know if he was. Hold on, was Bobby Jindal born in a?
I don't think so.
Yeah, Bobby Jindal. Was he born in the? Yeah, he was born in the United States.
Okay.
Yeah, like there you go. But anyways, he two immigrant parents. I mean, immigrant as fuck, and yeah, you got okay. Yeah, he was awful and all that, but okay, fine. But like, black folks can't win. It's like that. I hope somebody brings that up. But if I was one of the justices, I'd be like, what about Governor Jindal? Like Jindal, like you're telling me like a white guy can't run or black guy can't run? Come on now. And also, Chet, I will point out the 2 congressional districts that are majority black have black congressmen in them.
Role in the electoral process in Louisiana. And so the idea that you have to show that a party is the reason for the racially polarized voting would eclipse the entire Section 2 analysis, which is focused on ferreting out and ending race discrimination in the political process.
You've said several times that it's playing an outsized role. What's the proper size? In other words, is it wiggle room we're talking about, or a significant percentage? What is meant by outsized?
So this court has held for a long time, beginning in Shaw and in many cases since, that there's always an awareness of race. There are always racial considerations and even race consciousness in the districting process. What becomes potentially unlawful is when race is the motivating factor. That's what Miller versus Johnson taught us. That's what Milligan reaffirmed, that the line between the appropriate use of race and the use of race that will get us into the strict scrutiny territory is the dividing line between motivation and general awareness. And what I'm explaining here is that when voters are blocked by a white bloc vote that is so substantial that it usually overrides the politically cohesive vote of black voters, then we have at least a prima facie case of vote dilution. And
why should the black vote be politically cohesive? That's an interesting thing, right? She assumes in that statement,
yes,
like it overrides the black vote cohesiveness. It's like, why should the black vote be cohesive in the first place? Why should that be a thing?
Well, she kept on pointing out, well, it's, that, I mean,
are you saying that all black people think alike?
She has to, because otherwise, if you're doing it by race, this means you're doing it by party instead, and that looks really bad. Because then you're saying we can only trust the blacks for their votes. So, MLS David, how you doing? He says, would Janai lie to the court though? It's like that meme about the internet. It's like, do you really think people do that? Lie to a court? Yes, the Supreme Court 100% they will.
I don't have to assume that she's lying. I can believe that she believes every single word coming out of her mouth, which is even more depressing.
I don't know. She's a little too. She's had to have had some moments of cognitive dissonance where she's realized this is all bullshit, but it's too late now. But it's a very good point, Kurt. Yeah, it's like, at what point is she having to acknowledge the reality of it all?
If I may address the durational limit question, which came up, I'd like to talk about the fact that Section 2 is self-limiting. I know that there is a general concern about the indefinite use of race, and there are several reasons why that concern should be allayed. First and foremost, there is no precedent to suggest that a statute must dissolve on its own simply because it may require a race remedy. And as I've mentioned, race is not required by Section 2, but it can be used if that is necessary to address the Section 2 violation. In addition, the non-discrimination element of the 15th Amendment is a permanent right, and so should be the protection that Section 2 affords. And finally, this is a significant concern where Congress was very clear that it did not want to include a durational limit. Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction.
What's that, Kurt?
So good luck with finding a coherent answer to that question.
Well, yeah, it's like what we asked earlier. How long is long enough? Well, I'll tell you when we're there. Okay, well, when will we know? I'll just tell you. You'll know. And real quick, Stabby, you bring up a question here. Why aren't they doing anything that deals with the Second Amendment? There was a big case today argued dealing with New Jersey. And it was I'm gonna go over it because it's really, really good.
They took up a case on
the Third Circuit did. The Third Circuit just did a huge.
The Supreme Court took up a case on the Second Amendment. They took up what was it dealing with? Out of Hawaii. They took up a case.
Hawaii will happen, but there was a massive one in New Jersey dealing with the assault weapons ban. And basically, the state got painted in a corner, and they're going to have to say, like common use, none of that. Like they're basically just going to have to say, we don't like these guns, they're icky. And it's a really big one. It's coming down the pipe. We'll talk about this one, but there's a lot of Second Amendment stuff percolating. I know you live in Illinois, and I know it really sucks right now, but it will be better. For
I
you.
agree. I agree with the frustration.
Yeah.
Since the Supreme Court discovered the First Amendment existed sometime around the 1940s, they've been hearing like 3 half-dozen cases every year on the First Amendment.
Oh, I agree.
It's like,
I agree.
Why can't we take 3 to a half-dozen Second Amendment cases every year? And they don't have to be big. They can be kind of nothing unto themselves. The point is to like start getting the base of the casework going so that you have some foundation to play with. So like, why are they taking like 3 to 6 Second Amendment cases every year? I'll take small things. They don't have to be big.
Yeah.
Give me something to work from.
Well, the way I've tried to explain it to people before is, think about this is going to be like the civil rights movement. And like these voting rights cases, you hear all these cases they're talking about, chat. There are a gajillion voting cases. There are a gajillion civil rights cases throughout the 60s, 70s, 80s, into the 90s, even today, that got us to where we are with the application of laws and race. It takes a long time. So yes, the more the better. It's just right now there's a couple of really good ones percolating. It's just, I know like Illinois is not getting dealt with right away, and he lives there. I understand his frustration. So it's coming, chat. It's coming. I promise you it's coming. Say, did they not take up Duncan versus Bonta? No, they did not. I don't think it's been denied, but I don't think it's been gotten cert yet. So, yes, it's Illinois. It's French, didn't you know? So, but let's keep going.
And that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act. And also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has
How'd
it
Femla get
suggested
into
that
this?
any of those statutes.
I missed a trick. How did Femla get into this?
I couldn't hear it. Sorry, Kurt. What was that? Sorry.
Is it how the Family Medical Leave Act get into this discussion?
I don't. Hold on here. I mean, we can back up for a second here if you want. Because it's. Let's go back a little bit. Here you go.
And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act. And also,
I'm no
Section
wiser than
4E
when I
of the
started.
Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve.
Let her
in and of
explain it.
themselves.
She
Well,
may
first
impart her
Amendment.
black.
Sorry to interrupt. I don't think it's the statute. It's the
Let her impart her black wisdom on you. as a
Chat,
black
how did
woman.
Femla enter this discussion? I missed
She
something.
was just trying to argue that because things have been picked apart in Title VII, it didn't dissolve the whole act. So she's saying that like
But
because
Femla
things
has
have
nothing
been
to do with Title VII.
No, she was using it as an analogy, explaining like you can pick and part, you can kind of sever things out of this without destroying Section 2 of the Voting Rights Act. Is more what she was getting at.
Okay, all right.
She's struggling. She's trying to keep it alive. So she's saying you could sever things. It's okay.
Yeah, I understand that.
Yeah, so she was
That's
trying
why-
to say that
if
there.
that's why she cited it for the proposition you could sever pieces of law. Thanks, that's great.
Well, I mean, she doesn't have much. That's what she's arguing. You got to run. You got to run with your brung. So,
Okay.
we'll keep her going here.
particular application of the statute that entails the intentional, deliberate
Oh.
use of race.
I agree, it's a bad analogy, but when you don't have good facts and you
Yeah,
don't have
no,
good
it's like I
analogies-
heard the first time. I was like,
You-
how did FMLA enter this
Yeah,
discussion?
you make
Then we
bad
heard it a second
analogies.
time, I was like,
though.
I'm still not sure how FMLA entered this discussion.
Yeah.
Yeah, that was good. All right.
To sort people into different districts. That particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because,
Can I ask,
is that,
I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming that
my question is. Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting the 1982
Nelson, I guess I wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question, to understand, I think, that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking.
What the
as to
hell
whether
are
or
you
not
talking
certain
about?
Circumstances exist, and those circumstances that Congress.
Here we go, chat. The two queens. They're just gonna, boom, it's gonna be like fusion of intelligence. We're fusing together. It's like super colliding of black woman wisdom here. This is gonna be, yes, so it begins, yes. Just, yes, go off, queen, yes. Here we go. Here we go, chat. Just get ready. It's going to be a black hole of retardation from here on out. Yes, Kurt, you did get triggered. I feel that way when she talks too. So
No, it's just what she's saying didn't make any sense.
I know. And Fallen Preacher is correct. 70 IQ plus 70 IQ equals 140. So therefore they are smart. Actually, that's 3 standard deviations above average.
Yeah. Yeah. Great.
So, yeah. When you think about it, the math checks out.
Mm-hmm.
Like you said, Kurt, math works.
Uh-huh.
So here we go.
Is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
And so that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less and less as we see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean, it's a pretty significant showing to establish that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting test. It is data obsessive. It brings in experts and many other forms of evidence to establish a racial violation. There are many cases where the plaintiffs fail in bringing the Jingles 1 precondition or Jingles 2 or Jingles 3 before they even get to the totality.
So if we're talking about a time limit, you would say maybe it's with respect to the remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just,
no,
yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that prohibition of race discrimination on voting and does not require a time limit.
Thank you.
With the time I have remaining, I'd like to
that wasn't what
mention
anyone was talking about.
Yeah, it wasn't. And you notice it got really quiet. When there's dead air like that, that's not a good sign. When you're able to say, I actually want to move on to something, and they're like, the rest of the court's just quiet, like, yeah, okay. Even Justice Kagan's like, I'm sitting this one out. So here we go, chat. It's only going to get better from here for this woman.
There are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence of it, or the declining ability to show a Section 2 case, is because of the success of Section 2 over the past 4 decades. And we would be reckless if we determine that Section 2 somehow is no longer needed simply because it has been so successful in rooting out racial discrimination in voting. There's also, as I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Callais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use one of the many alternatives that are available that meet Section 2 and also comply with the Constitution. The liability finding in Robinson is undisturbed, and it must be remedied. If SB 8 is the inappropriate remedy, there are many other options for this court to pursue.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Yeah, let me pick up with where you left off, which related to the illustrative map in the Robinson.
And that's interesting. They let her get through that entire statement without interfering.
That's not usually a great sign.
Yeah, when you're just going, and that's the thing, chat, you're either hitting an absolute fucking home run, but you'd already have known that. If you're just rambling and they're not getting in the way, that it's bad. It's bad. And also, real quick, Jose for $5. Thank you, Jose. Is saying, has there actually been any Supreme Court case in the past 50 years where oral arguments actually swayed the ruling? Remember, you're not this is about sometimes helping frame the issue for the other judges, but also, especially now more and more with the media out there, you're framing issues for the public. And it's about the question being asked, just the answer is more important. But no, a lot of these judges have already made up their minds. There's generally nothing new you're going to bring up in oral argument. But that's true in most cases, in most situations. So, for example, if I'm in a court of appeals case and I'm writing a brief, that's going to be it. They're going to go off that in the case law. If there's an oral argument, you're generally not. It's kind of like debating destiny. You're not going to all of a sudden, oh my God, you're right. No, they've already got their preconceived notions. They already know what they're doing. Sometimes it helps flesh out ideas, and you could prove a point to the other judges or other parties. But you very rarely convince a judge. They've already got their idea made up for the most part. At least that's been my experience.
I think if you ask the question if there have been oral arguments that have caused their side to lose, I think you get a few of those. Because
100%.
Yeah, you could definitely tank an oral argument so bad that you.
Yes, yes. If you absolutely fuck it up, sure, but for the most part, like KBJ is going to be asking questions with the intent of helping this woman, and Clarence Thomas is going to be trying to torpedo her. So it all depends. But yes, generally speaking, you're not going to change the outcome.
I think Ginsburg probably when she was advocating for some of the sex-based discrimination stuff. Some of her oral arguments probably changed the map because she thought about how to reframe it.
Yeah,
and making it.
That's what
she made about discrimination against men. So yeah, I think it depends if you mean the oral argument itself, but her reframing of the issue to view it as discrimination against men definitely got her a lot of latitude when she was advocating. So there's that.
Yeah, and it can, but generally speaking, you're not changing minds. Generally speaking. So, but the point is, you do it anyway because if they happen to be teetering, you might have enough to push them the way you want them to go.
And also, the questions are often to poke at the other judges.
Yes.
They're not really for you. They're just poking at one of the other judges on the panel. That happens a lot.
Yeah. Yeah. Yeah, no, I mean, and like I said, yeah, you're asking questions to, influence the other side, influence your fellow judges, but sometimes, you're trying to influence the public, especially at the Supreme Court level. So let's keep going here, but that's a very good question, Jose. Very good question.
Case. And let me go back once again to what what the court said in Milligan. The minority group, this is the first Gingell's precondition, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question in the illustrative map, the second minority district in the illustrative map was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact. They met every traditional redistricting criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process.
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Yes,
it's a very
yes,
serious.
it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the black population within the district in question in the illustrative map was geographically compact. You have people from a rural area in the northwest part of the state, and you have people from an urban area many miles away, combined in a district, just for the purpose of getting over the 50% BVAP.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative map.
No, I'm referring to the illustrative map, although the same may be said about SB 8, but I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection that what the district court did and what the Fifth Circuit did on appeal was not to apply the correct standard under Milligan. Thank you.
Justice Sotomayor? Counsel,
You got told.
that
Yep, and here we go, guys. Here's the big brain shit. Here we go. So,
states maps joined people in districts from the far north all the way down and across the state.
That's correct.
The map that it put into effect. So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
All right. Now, you have not addressed the issues of the unconstitutionality, which is what this re-argument was about. Justice Barrett mentioned congruence and proportionality. Others have suggested that our Harvard case is appropriate. One, Louisiana has said that the use of race in any way violates the Equal Protection Clause. Would you give us a couple of lines on why those, assuming, as the Chief did, that Mulligan and all of our cases and precedents support you?
Sure.
The others are now saying, your adversaries are saying, even if it does, we should still declare this unconstitutional. I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is, in fact, working more in our favor, we believe, than supporting our opponents. And there are many distinctions between this case and the SFFA case. For example, Section 2 is a decidedly remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fullalove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan, which is controlling here, is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term, in the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination. And the Section 2 test gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns of getting at all discrimination in our electoral processes, but also being mindful of a potential allegation of racism against states and other state actors. And so Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions, including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of race is permissible in remedying discrimination.
Justice Kagan?
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black.
I think that's a relative. I think that's a relative thing there, but we'll see. We'll see about that.
Was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in
opportunity
Louisiana
districts. What a nice
has
euphemism.
been elected through a VRA opportunity district. And
What's that, Kurt?
It's like opportunity district. What a great euphemism, right?
Yes, the DEI districts. But yeah, she's pointing out, yes, when she talks about the VRA districts, chat, remember, it's the 6th and the 2nd, those two that run basically down the spine of Louisiana along the river.
In the ghetto,
yes,
where the voters cry.
Yes, and the snow cries. On a cold, dark, gray Chicago morn, stuffing all the vote ballots.
In the ghetto.
Ballots, vote ballots are born in the ghetto. Let's keep going.
Legislative representatives have been elected on those same districts. So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process. But it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
Thank you.
Justice Gorsuch?
When it gets to the remedy side, do you think a plaintiff in a Section 2 case has to come up with a map where race isn't the predominant factor in the map, or is it okay for a federal court to use a map on the remedial side that intentionally discriminates on the basis of race?
You do not have to use race to create the remedy in a map, and I think that
I'm asking whether one can. Sometimes you don't have to.
Yes.
I understand that. I'm asking, is it acceptable under Section 2, as you understand it, given our precedents, for a court to intentionally discriminate in a remedial map on the basis of race?
Not in those words, not for a court to intentionally discriminate, but I think it depends. There may be a circumstance where the only possible remedy is the limited use of race. I will say that I think those circumstances are rare, and the permissibility of race is constrained by strict scrutiny. This court has a very clear precedent around ensuring that race does not motivate the line drawer in a way that requires a map to be drawn that isn't narrowly tailored, that uses race for race's sake. There are already constraints between Jingles and Shaw that keep the use of race within constitutional bounds.
I understand that, but one argument is often, well, once you've found a Section 2 violation, you've got a compelling interest to go ahead and discriminate on the basis of race in your remedial map. And I'm just wondering, do you endorse that view or do you reject that view?
I don't endorse the concept of discriminating on the basis of race if discrimination has been established under Section 2 and a state determines that it needs a very precise incision of race in order to remedy that Section 2 violation, then Section 2 and this court's precedent supports that.
So a federal district court can sometimes to remedy a Section 2 violation.
Well, not a federal district. I'm sorry. I'm glad you emphasized that.
If I might just finish the question.
Yes.
Sometimes federal district courts order maps, and you're saying sometimes.
Oh, that's not good. That's not good. She started going down the road, and he's like, no, let me finish. And she should know better. This man is probably the most, on the Republican side of the court, the most minority-friendly judge you'll come across. He's
my favorite too.
Yes, no bigger support. Well, I was going to say, Chad, I mentioned this before. When he is off the bench, the Native American tribes will build statues of him. No greater friend the Native Americans have had than Justice Gorsuch on the Supreme Court. Or in the 10th Circuit, but let him finish his question here, because this is good. This is a very good question. Here we go.
But one argument is often, well, once you've found a Section 2 violation, you've got a compelling interest to go ahead and discriminate on the basis of race in your remedial map. And I'm just wondering, do you endorse that view or do you reject that view?
I don't endorse the concept of discriminating on the basis of race if discrimination has been established under Section 2 and a state determines that it needs a very precise incision of race in order to remedy that Section 2 violation, then Section 2 and this court's precedent supports that.
So a federal district court can sometimes to remedy a Section 2 violation.
Well, not a federal district. I'm sorry. I'm glad you emphasized that.
If I might just finish the question.
Yes.
Sometimes federal district courts order maps, and you're saying it's sometimes acceptable for a federal district court to order a map that intentionally discriminates on the basis of race.
I disagree with that formulation. So first and foremost, states and plaintiffs, as they put forth illustrative maps, cannot put forth maps that discriminate and that use race in an excessive fashion. The only actor that has broader leeway are states, because we give states breathing room. We give states wide latitude in order to balance their political interests and concerns.
So federal district courts can't discriminate on the basis of race in remedies, but states can?
Federal district courts can only order maps that...
Uh-oh. Oh, buddy. That is brutal. She's got nowhere to run now. He didn't even try. He tried to box her in, and there's nowhere to run. She's stuck.
Mm-hmm.
She's stuck. Let's see how she gets out of this one.
Are constitutional. And again, the constitutional boundaries are between Jingles and Shaw, which sometimes permit
states have more breathing room. So do they have the breathing room to intentionally discriminate on the basis of race?
They don't have breathing room to intentionally discriminate on the basis of race. They have breathing room to use race to remedy their own discrimination.
Okay, thank you.
Justice Kavanaugh?
Because the hang up there is the word discriminate, but your answer is that they can intentionally use race in those circumstances, correct? The federal district court.
If needed. And there are often a wide range of possibilities and alternatives that don't require that.
And then I think you said so long as it's not excessive, and you mentioned strict scrutiny as well, correct?
Correct.
But part of strict scrutiny, again, is the temporal limit. That's been part of strict scrutiny for a long time. And I think your answers earlier to that, to me, and when you were talking with Justice Jackson, were, well, Congress, defer to Congress. But when we're applying the Equal Protection Clause, or as Justice Barrett said, the 14th Amendment, congruent and proportionality, or 14th Amendment, deferring to Congress is, I think, not what we're supposed to do. So what if we're not just deferring to Congress? Is there anything you can point us to that would not allow it to extend forever? The intentional use of race, which you acknowledge in response to Justice Gorsuch.
Sure. Well, we maintain that there does not need to be a durational limit, but there is some guidance that this court could consider. So, for example, in Grutter, the court, Justice O'Connor, suggested that affirmative action did not need to endure beyond another 25 years. She forecast that another generation might need affirmative action, and ultimately this court thought otherwise in SFFA. So that sort of runway, that advance notice, that expression of an ability for Congress to intervene if it disagrees with the court or decides it wants to remedy on its own.
Based on that, so about 45 years plus another generation, about almost 70 years total. We're coming up on that timeline because 45 years after 1965 is 2010.
Yep.
And another 20, and a generation's about 25 years. So by my maths, about 2035, we'll be done. I'm sure she wouldn't agree to that. I'm sure if you said, if I was one of the judges, I would have been like, so how about 2035? She'd be like, well, no. It's like, yeah, because once again, the answer is, when will we be done? Never. Never is the answer.
The answer is tomorrow.
Yeah.
Tomorrow never comes.
Well, there you go. I was going to make the 2 weeks joke.
You're always a day away.
Yes. That is true.
that is the type of guidance I think this court should consider if it feels that it must pursue a durational limit on Section 2. And again, we don't believe that's necessary.
Justice Kennedy in 1994 in Johnson versus DeGrande said a couple of things I just want to get your reaction to. He said the sorting of persons with an intent to divide by reason of race raises the most serious constitutional questions. And he added that explicit race-based districting embarks us on a most dangerous course. It is necessary to bear in mind that redistricting must comply with the overriding demands of the Equal Protection Clause. Do you take issue with what he said there?
No, what I think is missing from the understanding of Section 2 is the work that it has done to advance the goal of ridding our electoral process of race. It brings racial groups together, and as I mentioned earlier, many of the
translation to her, fuck the Equal Protection Act, fuck equal protection when you're talking about white folks. Notice she wouldn't answer the question. She completely dodged that and ran away from it.
Of course.
Because she has to come back to, well, yes, racism is racism, and yes, some racism is okay. And she doesn't want to say that. Notice she just bailed out of that question so fast, and I'm hoping Kavanaugh pulls her back on that.
VRA opportunity districts ultimately convert to non-majority minority districts. Not all VRA opportunity districts are majority minority districts. And in fact, we see greater racial harmony and less racially polarized voting as a result of Section 2 districts. So Section 2 is addressing a pre-existing problem. It is not producing it. And in fact, it reduces it more broadly across society.
Thank you.
Justice Barrett?
So we've assumed, without deciding, this is picking up on Justice Gorsuch's questions, that complying with Section 2 is a compelling interest for purposes of the 14th Amendment. Correct. And now this is kind of picking up on some of Justice Alito and Justice Thomas's questions earlier. How are we to think about that when we're thinking about the Robinson litigation? Because it was a preliminary injunction, and Louisiana, of course, argued there that no, it wasn't a violation of Section 2 to have those maps. So I guess, how do we judge the compelling interest in avoiding a violation of Section 2? If the state doesn't really think it violates Section 2 and it hasn't been finally adjudicated yet, how do we approach assuming that compliance with Section 2 is a compelling interest, how do we think about that in a context like Robinson?
So states can, for good reason, draw a map that addresses Section 2 prophylactically. Here we have a finding from a district court based on a robust evidentiary record that we were likely to succeed on our Section 2 claim. This is not the first case. There are many cases that have provided the basis for an opportunity map to be drawn just on a preliminary injunction motion. And again, that finding by the lower court was affirmed by 2 federal panels of the Fifth Circuit, and this court had an opportunity to revisit the Robinson litigation and did not.
But what if, district courts sometimes make errors of law, right? So what if the district court, I guess I'm trying to figure out how much.
That right there, guys. So the judges are not immune to what goes on in the world. I think that's Barrett also expressing her frustration that, you know who gets it wrong all the fucking time? All these goddamn district courts we've had to overturn. She's like, we wouldn't have, and because she actually came out with this. There was she actually gave an interview, and people were talking about the shadow docket, why they were doing it so much, and why it was so, when they would make an action, they didn't really talk about it. And she said, if we talk about it, you might think we've decided the issue already.
Right.
Like we rule on the basic issues. And that right there sounds like a woman who's very frustrated with the meddlesome district court judges. Like, I think like her, she's like, I'm not going to go that far that they're not right all the time. I've had to tell a bunch of them they're wrong the past 6 months. So I think there's a little of that boiling up in there too, chat. I think there's,
and some of them have been defying the Supreme Court.
Yes, some of them have openly told us to fuck off. So, yeah, and then this is where it goes from here. So, and guys, the case that they're talking about, Jingles, it's Thornton v. Jingles. It's a 1985 case, and that's where we kind of got this whole idea of having to have these majority-minority districts. That was something that came about in the 80s where it really started happening. So, but yes, let's keep her going here.
weight then the district court's finding has in comprising that compelling interest in avoiding the Section 2 violation. Do you see what I mean? Like, what if the district court was just wrong, and what if the state thinks that the district court was wrong?
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. I mean, it got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question?
Oh, Chad, I also forgot to mention there's another case, Robinson v. Callais. That's another case. These two got consolidated, and this is basically they're re-arguing this case. Notice it's a 2.5-hour window that they're doing here. So there's a lot of oral argument you normally don't get. So that's the other thing. Number one, it's already been a re-litigated issue that's getting re-argued. So there's a lot of uniqueness in this case that you normally won't see. Because you heard them mention we've already kind of dealt with this. But anyways, notice this lady's talking and Amy Coney Barrett's like, answer my fucking question. This is a bad, you are in real trouble when they're cornering you like this. That's never a good sign.
If the state thinks that the district court was wrong.
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. I mean, it got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question, like at the time Robinson was decided. If Louisiana thought that the Robinson court was wrong, that the district court was wrong, but it wanted to avoid the court-imposed map, wanted the opportunity to draw its own map. Justice Kavanaugh's been asking you what role race can play without running afoul of the Equal Protection Clause. And the state would have to say at that point, well, we're weighting race heavily because we have a compelling interest in avoiding a Section 2 violation. And the state's position might be, we don't actually really think that we violated Section 2, but we have a litigation risk. We know that if we don't draw this other map, the court may impose one. On that understanding, on those facts, not concessions and whatever is made, is that then a legitimate, compelling state interest when there is the possibility and the state in fact thinks that the district court was wrong?
It is still a compelling governmental interest. The state can do what it did here, which is to appeal to the Fifth Circuit, and the Fifth Circuit considered the same evidence and unanimously found that the Robinson court was correct. Yet another Fifth Circuit panel also affirmed that decision.
Justice Jackson?
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
That's correct.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and like the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing, and the Robinson court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson court's decision is before us right now, because what I understood is that as a result of the Robinson court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson court has identified, and we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court.
Yeah, we need to rewind that. We need to rewind that, guys.
What is she confused about? Is she confused that someone thinks it's not a compelling interest? Is that her point of confusion?
I think so, but this, once again, it's hard to tell because she's retarded.
Well, she said so. I thought it was a procedural thing at first because she's talking about.
Yeah.
Oh, I thought we kicked it back, and there was a new map. But I thought where she was going with this is, the lower court hasn't adjudicated the new map yet. So like we sent it back for remand.
Yes.
And then the legislature did some stuff to intervene, and now we're being asked to adjudicate the new map, but the lower court hasn't spoken to it first, so we don't really have jurisdiction right now.
J-Rock,
that's where I thought she was going.
Yes.
And
this
then
woman is not smart.
And then at the end, she started saying, "Well, it's compelling interest," and it seemed like she's saying she couldn't fathom why the other side could or would want to argue it's not a compelling interest. I'm like, I can think of a reason why they could argue it's not a compelling interest. Now, I'm not saying that, it is or it isn't, but like the way she ended is like she was taken aback by the prospect that there could be someone who could believe that it's not a compelling interest. I'm like,
yeah,
those are two different things. I'm very confused. What exactly is the problem?
Yeah, and if we're to a compelling interest, like we've changed our our criteria. Like, this is. I don't know what her problem is.
Is she trying to say that it's inherently compelling, which sort of flattens the strict scrutiny test? Because
which you don't want that as the
that doesn't sound right. So anytime there's a map which has racial implications, it's inherently compelling. Is that where we're going?
Yeah,
I don't know what we're doing now.
Yeah, I don't know either. Maddie B says, just want to thank you for having Kurt on. Well, thanks, Maddie.
Chat seems about 50-50 with me, I guess.
Yeah. Messel Spank says, who let the dog in court? I don't know. Lainey's been barking a lot. I think Lainey wore her bark crouch. She quit barking now. Boosh just says,
have you tried a shock collar?
Yeah, I know. I thought about that. No, we don't do that here. This is we don't subscribe to the Turkish dog raising method. Bush says, so you want black people to do as told and have more voting power than whites, but you aren't the racist. Yeah, I agree. Yes, it's funny like how that works. It's funny how that works. Bob says, could Kurt squat my? No. He's got a ways to go if he was trying to do that.
How much do you weigh?
A lot.
Okay.
A lot more than you're squatting.
Okay.
He never says Bobby Jindal sucked. That's not the point.
We'll do it as a piggyback, right?
Yeah. Zero Skill starts talking about them being disabled. Well, yeah, that kind of answers that thing, though. Let's see here real quick. Cheese Italian's been a member for 6 months. Says, what's worse, the Italians or the Irish? The French. They're worse. Jose says, how is C-SPAN on the air if the government is shut down? Well, C-SPAN is, I think they already got their funding, number one, and they also have other independent means of funding. Great Loner says, the reason why the 19th Amendment needs to be repealed. Well, yeah, I mean, to be fair, though, you don't need to be able to vote to be a lawyer, so. Thank you, Great Loner. Dolly Talk for $2. Dolly, good to see you, says, chirp. Yes. Yes, they did. Ugly Thumb, or Thumb Ugly, says, Amy Comey is a bullshit white saviors for She Lies Nelson. I mean, she just kind of laid Amy Comey Barrett just fucked that woman raw. I don't understand what you were hoping there, but no, like that was actually pretty based. Jose saying, are you saying these oral arguments are basically black on black violence? Yes. Ketanji Brown Jackson is unintentionally hurting this woman and doesn't realize it. Destroying the arguments. Are we going to do this for any other ethnicities or races? I don't know. Probably not. Only for blacks. Mikey says, catching up real quick. Good to see you, Mikey. Says, Nelson Lady said the Section 2 usage has gone down by over 50% anyway, but we still need to keep it, arguing its own shelf life. Well, I think she's trying to argue because there is a fallacy, and it's like what mentally ill people do. I'm taking my pills. I feel better. I don't need to take my schizo pills anymore. Then they go back to being schizo. So the idea is, her argument is Section 2 has worked so well, we haven't had to use it anymore, but that shows the need we need to keep it just to make sure that things stay in check, is what she would probably argue there. And you can argue whether or not that's bullshit, but EDW Raptor says, shouldn't Barrett recuse herself seeing she's from Louisiana? Really? She doesn't sound like it. But no, I mean, she, like, if she was involved or knew Louisiana politics or something, maybe, but...
Everyone's from somewhere.
Yeah, I mean, yeah, that's the thing. Like, she was born in Louisiana.
Nice.
So, okay. And, did not know that. So,
born in a bayou?
Yeah, sounds like it. Her dad worked for Shell, and her mom was a French teacher. Ho, ho, ho.
Nice.
So, yes. And then Connie Desquad for $5 says, can we deport her to Liberia? No, sadly, probably not. So, let's keep going. Let's keep going here.
And a lot of evidence, and they do the thing, and the Robinson court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson court's decision is before us right now. Because what I understood is that as a result of the Robinson court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson court has identified. And we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Callais case to support that.
Thank you.
Thank you, counsel.
There being an interest isn't the same thing as there being a compelling interest. She does know that, right?
You'd like to think so. You'd like to think so. But as J-Rock did so eloquently put it, what this woman doesn't know could fill the oceans. And the sad thing is she doesn't realize she doesn't know it. The sad thing is she does not know that.
Well, if she needs a primer on tiers of review, I'm available for, tutoring.
And then EDW, he likes to think he's from Louisiana, but we know our real Louisiana person on this chat is ag biochemist. He's trying to tell us she's only from the New Orleans suburbs. Well, sir, once again, I'm only going to defer to our official Louisiana person. Our true, the mud pumping through his veins, unlike you, sir, is ag biochemist. So I'm not going to trust that.
Like the guy from that song from Wheatus, is it? Or, yeah.
From Wheatus? Oh, really? It's from Louisiana or New Orleans?
My name is Mud.
Oh,
my
yeah.
Name is Mud. That's Wheatus song. Is that Wheatus?
I think it actually is, maybe. My chat's better about that.
My name is Mud. Mud.
Yes, she says, excuse me, white man. I happen to know all about it.
Primus. Sorry, not Wheatus.
Primus? Okay.
Sorry, guys. My fault.
My name is Mud. Primus. Yeah, there we go. Are you volunteering to be her law clerk? I would not punish you with that type of that would be a rough. You would need the Medal of Freedom after that one. You come out of there like the Vietnam prisoners of war. That would be so rough. But anyways, here we go. Let's see what happens.
Chief Justice, and may it please the court. Race-based redistricting is fundamentally contrary to our Constitution.
This is I love how it's like on both sides. It's they did have the white guy arguments, but yes, Louisiana Solicitor General Benjamin Aguinaldo, I don't know, whatever. But anyways, this guy does a great job. Here we go.
Requires striking enough members of the majority race to sufficiently diminish their voting strength. And it requires drawing in enough members of a minority race to sufficiently augment their voting strength. Embedded within these express targets are racial stereotypes that this court has long criticized. They assume, for example, that a black voter, simply because he is black, must think like other black voters, share the same interests, and prefer the same political candidates. And the stereotyping system has no logical endpoint. We are 40 years removed from jingles, and yet, according to my friends on the other side, nothing has changed in the voting and housing patterns in Louisiana that require race-based redistricting. These problems are part of why we never wanted to be here in the first place. They have placed states in impossible situations where the only sure demand is more racial discrimination for more decades. But I think if anything is clear in this court's dedication to eliminating all racial discrimination, it is that the Constitution does not tolerate this system of government-mandated racial balancing. I welcome the court's question.
That's so based. I don't know if I can handle that.
Louisiana switch side.
It is very based, and Uncle Clarence again leads off with his deep, bassy voice. Here we go, chat.
Since our last argument.
Your Honor, we told the court at pages 1 and 2 of our original opening brief in this case that our predicament in this case presents as good a reason as any for the court to reevaluate its voting precedents. We told the court at page 18 of our original reply brief that we thought this would be a different case if the court thought it was worth revisiting the longstanding assumption that compliance with Section 2 is a compelling interest. Your Honor, we thought all along, and in my colloquy with Justice Kavanaugh back in March, we discussed our longstanding position in our state legislative map litigation, where we have taken the position that Section 2, insofar as it requires race-based redistricting, is unconstitutional. This court's re-argument QP squarely tees up that question, and so our duty of candor requires us to give the court our honest answer to that question.
General, the race-based redistricting that you're now objecting to is redistricting designed to remedy a specific, identified, proved violation of law. More, a specific, identified, proved.
Now, chat, Clarence Thomas had to ask, you guys were here before us and you argued a different position. And yes, as an officer of the court, hey, if things change, you have to tell them. And he's like, look, I'm being honest. We changed our position. Here's why. But you can. It's just if there's a reason, you have to explain why.
Racial discrimination by the state. That's the way in which the race-based districting is coming in. It's coming in as a remedy for specific, proved discrimination on the state's part. How could that possibly fall subject to the categorical rule that you're suggesting?
Your Honor, I respectfully but firmly resist the premise that this comes to the court on a finding of specific discrimination by the state. I think if anything is clear about how Jingles plays out on the ground, it is that once you run the 3 preconditions and get to the totality of the circumstances, it's anyone's guess what the alleged violation is. I mean, I think Justice Thomas' colleague...
General, I mean, what Jingles does, and, you know, the idea that this is like 50 years later, this is not a kind of Shelby County thing. Where one could say that Congress had acted and 50 years later, you know, the conditions on the ground might have changed and there would be no way to respond to that change. Because what Jingles does and what these Section 2 suits do is they ask about current conditions, and they ask whether those current conditions show vote dilution, which is violative of Section 2. So they say, is there racial segregation, racial residential segregation now? Is there racially polarized voting now? And when the state fails with respect to those issues, when those conditions obtain now, what our precedents say, and what you're asking us now to change, what our precedents say is that when those things operate currently, right as of now, and are proved in a courtroom, that, that still there can't be a race-based remedy.
That's correct, Justice Kagan, and I think the 2 trends that my friends on the other side point to, the rates of residential segregation and the rates of racially polarized voting, are what allow them to get past the Jingles preconditions. They told you at page 33 of their yellow brief that those things are worse today in Louisiana than they were in the 1980s, and this court said at page 228 in Northwest Austin that those sorts of factors are not evidence of intentional discrimination. That's not intentional discrimination, Justice
It's not intentional discrimination because Section 2 is not about intentional discrimination. Section 2 is about effects discrimination, is about Congress saying, and specifically in response to a decision of this court, that intentional discrimination and the values behind that prohibition can only be vindicated if Section 2, under Section 2, the state shows that the effects are not discriminatory. And, you know, Congress put this court in its place when it said that. And so what Section 2 does is to say where the effects are discriminatory, such that people are not having the same, African Americans here are not being given the same voting opportunities as white people are, then a remedy is appropriate. That remedy doesn't have to be race-based, but sometimes it is race-based in order to correct the racially discriminatory situation that exists in the state right now.
And Justice Kagan, if Congress had attempted in 1982 to make a record of intentional discrimination in districting, and today, if there were a record of intentional discrimination in districting, then there might be a congruence and proportionality argument to sustain race-based redistricting as a remedy. But I think something that you don't see in the congressional record in the 1980s and something that doesn't exist today is that justification. And that's
I'm
why
sorry,
I think,
counsel. That's because they weren't dealing with the history of it. They're dealing with the current situation. And Gingles is, as Justice Kagan pointed out, what's happening today, and are there lingering effects of the past? The one thing I look at is Alabama's maps for the last 30 years. The map that the Robinson Court found cracked and packed voters was a map that's been in effect almost the entire history of Alabama. That map was put in effect because of discrimination. So it's going to have a lingering effect. They wanted to pack white voters. They've been doing that. And they wanted to uncrack black voters as much as they could, and they've done that. And it's only section...
I mean, to be fair, there was a problem with black voters being cracked in the 80s. I mean...
But yeah, keep trying.
I was waiting. I kept on, like, because, like, I don't, like, everybody's like, he's going to say it. He's going to say it.
Fine.
I'm sorry, Chad. I'm sorry. I had to get it in there. But no, and guys, this is, there wasn't a problem of it before. It's like, wait, we just had the Voting Rights Act passed 17 years before in 1982. So the wisest Latina is struggling. Also, she looks really rough in this picture. I'm not going to lie. Ooh.
In Section 5 that kept them creating one majority district. But using race is a part of redistricting always. We've said that the only actionable part that's intentional if it predominates. But race is always a part of these decisions, and my colleagues are trying to tease it out
always
in this
a part
intellectual
of these
way that doesn't deal with the fact.
How do you know that?
What were you saying, Kurt?
How do you? She said race is always a part of these decisions. Like, interesting. How do you know that?
Yeah, we just literally.
How do you know race is always a part of these decisions?
We just spent 45 minutes talking about, well, it doesn't have to be, and it's all we're speculating on why it's
right. It doesn't have to be, but always.
Yes, and why is race a decision when we said, well, black people don't always vote Democrat? Well, then therefore, like, why would we care? I mean, these statements, they all start contradicting themselves after a while. So, yeah. Karen says, this is fascinating. I'm not joking. It is very fascinating.
Did you see my video where I had a live discussion with ChatGPT about what was a woman?
No, I'm sure you probably caused us to destroy like how many gallons of water.
It was very interesting.
Well, Everett Scott says Nick's going off on me and Kurt. I mean, I good for him. Like, I'm having fun doing this, so I don't know what to tell you.
What was that? Nick saying something about me?
I don't know. He's probably calling me and you fat or something. I'm not sure. Like,
well,
you know, like in the meantime, I'm over here doing this, so I'm good to go.
Yeah.
So that's all that matters.
I'm still not an adulterous cock.
I don't even. Yeah,
using.
but you know, even at this point, Kurt, it's like I got better things to do, man. We're gonna watch this. We're gonna have fun talking about this, and then I'm probably gonna play some Sniper Elite afterwards. So like,
nice.
I'm gonna do my thing. Like I really don't care anymore. Like I said, it's like the drunk guy at the end of the bar. Like, cool, bro. Cool.
My weightlifting is going very well, by the way.
Yeah. Like I said, you're up to 3 wheels on each side, man. That's.
I'm gonna after the stream is over, I'm gonna go to the gym and do some deadlift today.
You gotta get some smelling salts, Kurt. That's like a big thing.
That'll be good.
Yeah,
right.
All right, guys. So, anyways, we're gonna keep going here. Let's keep going.
This is used to help people. Legislators might try to keep an ethnic community in one district. They might consider it to get a sense of which district.
There's no just say black. That's the only ethnicity we're talking about or have ever talked about. There's no other ethnic community. But notice she can't bring herself to admit, yeah, this is only protecting black folks. But anyways, let's keep going.
Draw an incumbent into. They might review it to predict what kind of issues a district voter might be particularly interested in. They might use it to inform partisan goals. We permit all of that. What you're saying to us, if you use it to remedy past lingering discrimination, intentional discrimination, then you can't use it. You can use it to help yourself achieve goals that reduce a particular group's electoral participation, but you can't use it to remedy that situation. That's what you want us to hold.
Justice Sotomayor, my humble point is that the government has no business telling citizens in which districts they may live or what voting
But
power
it's
they
not
exercise.
doing that, counsel. The 6 plaintiffs in this case are white plaintiffs who live in a district with black voters. So no one's keeping them out of that district. No one's stopping them from participating in the voting process. No one is stopping them from trying to run candidates or support candidates that reflect their views. But this state is stopping black voters from doing that in many districts because it's packing them into areas that whites overwhelm them. I don't understand this.
So, Justice Sotomayor, let's look at the facts
If
in this
you can
case.
use race in some ways that are positive, why can't you use it to remedy something in some ways?
Your Honor, my friends on the other side walked into the Middle District of Louisiana. May I finish very briefly?
Yes.
Walked into the Middle District of Louisiana and demanded a majority black district. What's the purpose of that kind of district? The avowed purpose of drawing a majority black district is to diminish the voting strength of some racial groups and augment the voting strength of others. And
thank you, counsel. Justice Thomas?
What role did Robinson play in the development of SB 8?
Justice Thomas, Robinson is the only reason SB 8 exists. We fought tooth and nail in the Robinson litigation itself in telling the courts that we did not think the Constitution permitted us to draw a second majority black district. As you know, under protest, we drew SB 8 because the threat was that the federal courts were going to do it if we didn't. And that's, I think that's the best way to conceive of why SB 8 exists. We would never pass SB 8 in the first instance without Robinson, Justice Thomas.
What were the findings in Robinson?
The finding by the Middle District in Robinson was that the plaintiffs in this case were likely to show a violation of Section 2. And the likely violation, and I'm using very broad terminology because I do not know what the underlying violation is. I can't articulate that for you, Justice Thomas, because I don't think anybody can. But I think the finding in the district court's mind in that case was that the likelihood of a Section 2 violation meant that a majority black district was required, a second one. And I think that was the bottom line. And when our legislature saw that, we understood the marching order, and that's why you see SB 8 as it exists today.
Just briefly, what were the findings that led to that conclusion?
Well, Your Honor, running through the preconditions and the totality of the circumstances, I think the totality of the circumstances did most of the work for the Middle District in Robinson. Senate Factor 1, the official history of past discrimination. Justice Thomas, we can never outrun the bad era of poll taxes, of grandfather clauses, of literacy tests. I think we're always going to lose across the board on that kind of analysis, and that's what the Middle District in Robinson focused on, is how bad was Louisiana in the 1930s, 40s, 50s, 60s, and, add all that together, and at the end you have a vote dilution finding that I don't think is clearly articulable in the way that SFFA requires a finding of discrimination to be.
And this is a great point. Like, yes, it was bad. Poll taxes were bad. The reading tests were bad. Yes, it was really, really bad. But his point is, these courts are never going to let us get away from it. And that's the problem here. Like, yes, it was bad. We're sorry. Racism, not good. What more can we do at this point? So, yes, all Democrat policies as well. And if you guys, I think we talked about it, Kurt. I don't know if you've ever gone over one of these before, but those reading tests they had you make.
Yep.
To take
They're
back in the
pretty bad.
day.
They're pretty bad.
Yeah, it's like I'd fail it.
Yep.
So why would literacy tests be racist? Because if you were not, so here's how this would work. I'm running the polling booth, Meso Spinks, and I'm running the polling station, and I know you're voting for the guy who's not part of he's running against the incumbent. And you're white, I'll make you take the test. And you take the test. And I look at it and say, sorry, you failed. You know what happens? If you start acting up, guess who I'm calling? The sheriff. And he's going to come crack your fucking skull. So that's how literacy tests were used back in the day. There was an entire reason why those were used. Generally speaking, though, you would only use it on black folks, just to keep them out from voting. But you would also use it as a political tool. But yes, primarily they were used against black folks because maybe they couldn't read. But even if they could read, Yeah, I mean, hell, we'll bring one up right now.
Yep.
I mean, they're completely
and the time frame is so tight too, because you had to answer these very complex questions.
Yeah,
like 10 minutes or something.
Oh, even oh, here we're gonna do one. We're just gonna do one real quick. We're gonna do one real quick.
This is gonna go really well.
Yeah,
well, I already know it's gonna go great.
Oh, Jesus Christ, Kurt, come on.
What?
Okay, so here's a literacy test. Here's an example from the state of Louisiana. Actually, draw a line around the number or letter of this sentence. What does that mean exactly? Where do I draw the line, chat?
How do you also draw a line
around the number?
How do you draw a line around?
Do I draw a line around? Does that mean a circle? Well, no, because a line has a beginning and an end point. Sorry, that's not the answer we're looking for. A number or letter of the sentence. Which letter? They're going to tell you, answer the best you can. Draw a line under the last word in this line. What does that mean? Cross out the longest word in this line. Well, does that mean I have to cross out longest?
I guess.
Maybe that's what they mean. Maybe it's not.
Draw a line around the short. Line will it be line? So that one, yeah.
Yeah, I mean, sorry, there's ways you can answer this. Stacy says around. Well, it says around the number or letter. Okay, you know what happened? Sorry, wrong answer. Sorry, you failed. If you don't leave, I'm going to get the sheriff and we're going to beat you to fucking death. Do you really want to chance that? We'll burn your fucking house down.
One wrong answer denotes failure.
Yeah.
One answer is failure.
Yep. Draw a line around the shortest word in this line. I mean, you'd think it's A, but maybe that's not what they're looking for. Draw a circle around the first letter of the alphabet in this line.
The first letter.
Yeah. Circle the first letter of the alphabet, meaning, does that mean circle the first time the letter A comes up? Or does it mean the first letter, C? I don't know. And the space below, and this it's cut off here, but draw 3 circles, one inside engulfed by the other. Well, does that mean I have to draw them concentric? Like a bullseye? Does it mean I draw them and they're going to say, sorry, the answer was we were looking for is this? Like, we don't know. Like, do we draw it like a lopsided titty where the bad plastic surgery? Yes, Stacy, exactly. It's like a field sobriety test. Exactly like a field sobriety test. You could completely answer it right, and they still determine you failed.
This one isn't so bad. I've seen some ones, especially like math.
Well, this is
fucking impossible.
Example. Yeah,
this one isn't so bad.
Yes, J-Rock says
it's like fuck me.
Sean failed. He's black. Well, you failed too, J-Rock. We all fail. That little voice says one. Yeah, it says one inside the other. Well, that's also a good point, technically, that little voice. So it says draw 3 circles, one inside the other. Okay. And then maybe I have to draw it like that. Sorry, that's not the right size circle we're looking for. It has to be bigger. Like, there's no way to answer this and succeed. That technically is following directions. So this is how you know Sean isn't white. He can't figure out the simple test. Yeah. But remember, if you're voting and you're voting for the wrong party and you're white, I can make you take this test too, because I have to question if you're literate or not. But it's my job to determine that. So, yes, if you fail the test, you automatically get an N-word pass. I agree. One circle only engulfs. Snarf, that's not clear. I would argue it means one inside the other, and most of you would read it that way. You would draw 3 circles engulfed, Once again, there's no easy way to answer this. Yes, just easily hand it in with a $20 thing. No, you can't follow preacher. You're voting. I'm the Democrat poll worker, and you're voting for a Republican guy, and we're talking about like King Huey Long, Louisiana. Sorry, you're not voting Republican today, sir. Only Democrats are voting today. You tried to bribe me. I'm calling the sheriff. You better get out of here. We're going to beat the fuck out of you. So, yeah, that's, there's no way that it is objectively true to answer. Correct. Just so you understand, chat, that's what this is meant to be. There's no bribing your way out of it because they would never work that way. So let's get back to it. But just so you guys understand what a literacy test is, these things are, yeah, there's some bad shit. Yeah, I would take your money and still threaten to send the sheriff after you. So.
Justice Alito?
Can I clear up a couple of factual points that have been brought out by the questioning? Your HB 1, enacted in 2022, followed to a large extent the map that you had for the prior decade. Isn't that right?
That's exactly right,
It was
Justice.
suggested that that prior map was discriminatory. What was the origin of that prior map? Do I remember correctly that it was pre-cleared by the Justice Department?
Twice. That's correct, Justice Alito.
So it wasn't, there's no finding that that map was based on discrimination, and that by following that map, you were perpetuating prior discrimination.
No, Justice Alito, and I think that's why I firmly have to resist any suggestion that the Louisiana State Legislature is out here targeting minority voters and trying to abridge the right to vote. That is just completely unfounded.
As to the suggestion that there was a proven violation in the Robinson litigation, that was a preliminary injunction, right?
That's correct, Justice Alito.
So there wasn't a finding that there was a violation, at most a finding that there was likely to be a violation shown. And is it not correct, for the reasons that I brought out in my questioning of Ms. Nelson, that what the district court did there was not to ask whether the minority group was sufficiently compact, but whether the district itself was sufficiently compact?
That's exactly
correct,
right, Justice
Gabby.
Alito.
Fair
And if you
enough.
look at the black population in Louisiana, I mean, it is all over the place. You can identify pockets of black voters, but they are dispersed across the state. There's no way you can conceive of that population as compact.
Thank you.
Justice Sotomayor?
I may be remembering the record wrong on this because it was a while back, but if I recall, the district court looked at the three main parishes that make up District 6 now, and looked at it and said they have a commonality of history. Many of its residents go from where they live near the Baton Rouge area to work or go to school, and they go back to their communities. They have long family ties between the communities and among the communities. There may be a difference in education and some income differences, but that's true of all the districts in Louisiana. You've got the districts that are protecting incumbents, where in the north there's less money than in other areas. So those differences are not meaningful. But I thought the district court did a very careful analysis of the commonality of interest of that black community. You may disagree with its finding, but it did do that analysis.
Your Honor, no doubt the Middle District purported to run through the Jingles analysis, and it said, it will be the
You're
unusual.
disagreeing with it, but it did do that.
It did what this court's precedents allow lower courts to do. And Justice Sotomayor, my only point in response to that is to say, when the district court was asking about what the minority group does and thinks and prefers, it is exactly the sort of racial stereotyping that this court's precedent says is impermissible.
Counsel, with respect, the last time the SG was here before us on behalf of your state, they said that race did not predominate just with your creation of District 6, because what you were trying to do and why it's oddly shaped was to protect incumbents. Are you walking that back?
Your Honor, our position in our supplemental briefing on racial predominance is as follows. If race is a non-negotiable in the drawing of a new district, we think that should satisfy this court's predominance analysis. And the argument you...
But that's just it, which is, was it? What really was non-negotiable for you was nonpartisanship.
That's...
And you could have picked one of the other maps, the illustrative map. You didn't have to, but you drew this because of your partisan needs more than because of race.
We drew it for partisan reasons, Justice Sotomayor. My point and the point we make at the end of our opening supplement.
Every gerrymandering's done for partisan reasons, though. It's always done for partisan reasons. What the fuck?
Yeah, really.
Yeah, like,
It's-
bitch. Like, what?
That is the goal.
Yeah.
That's 100% the goal.
Yeah, like, yeah, no shit. You figured it out. You cracked the code, honey.
Supplemental brief is to say, when this court's racial predominance questions ask about non-negotiability, it should matter if race is the one non-negotiable factor or it's one of 10 non-negotiable factors.
Well, but we always talk about what predominates, and what predominated here was politics. That's what you said the last time. Thank you, counsel.
Justice Kagan?
General,
Very
a couple
dismissive.
of years ago when we decided Milligan, the party there, state there, made several arguments that we specifically rejected. And in the answers that you just gave to me, it seems to me that you've repeated each and every one of those arguments that we rejected. So I'll just run through a few of them. What they said was that the 15th Amendment permits Congress to legislate against only purposeful discrimination by the states. We rejected that. We said, no, Section 2, which is an effects-based test of vote dilution, is permitted under the 15th Amendment. There, in Milligan, the state said that the 15th Amendment doesn't authorize race-based redistricting as a remedy for vote dilution Section 2 violations. We said, no, that wasn't correct either. You just repeated it, but we rejected it. And they said that we should adopt an interpretation of Section 2, and I'm quoting here, that would revise and reformulate the Jingles threshold inquiry that has been the baseline of our Section 2 jurisprudence for several decades, and we rejected that as well. So each of the propositions that you're putting forward here, that Section 2 has to be limited in some way just to purposeful discrimination, that it doesn't authorize race-based redistricting as a remedy, and that we need to fundamentally overhaul the Jingles threshold inquiry, was rejected, I don't know, 3 years ago, 2 years ago, by a majority of this court.
Justice Kagan, the court has never addressed and rejected the two key parts of our argument here. The first is the court has long assumed, without deciding in cases like Cooper versus Harris, that compliance with Section 2 is in compelling interest. We're asking the court to finally decide that question and answer it no. The second question, the Allen court...
Well, but you're asking us based on arguments that have been specifically rejected by this court over many decades and 3 years ago.
Your Honor, this is an antecedent question that the court has routinely left open in its voting precedents, and that's why we're asking the court to address it here. If I could just answer the second question that the court has left open, in Allen, the court left open the question of whether a logical endpoint is identifiable in the race-based redistricting context. And our submission to the court is it's time to answer that question and answer no, because there is no logical endpoint to race-based redistricting under Section 2 as the court has construed it.
Justice Gorsuch? Justice Kavanaugh?
I'd like to get your views on pages 25 and 26 of the Solicitor General of the United States' brief, where they say this court should hold that the plaintiff's illustrative district cannot disregard the state's political objectives, and further say that Section 2 plaintiffs cannot claim a lack of equal openness or politics rather than race as the likely reason for the state's refusal to create a majority-minority district. You have thoughts about the Solicitor General's approach, and then in the course of answering that, do you see differences between your basic submissions and the federal government's submissions? I'm going to ask them that too.
I do, Justice Kavanaugh. I do think the top line response is we like the proposal and we don't. I think we like it insofar as you know from our original briefing and our supplemental briefing that the thing we want most as the state is clarity in this area of the law. And so any remodeling of Jingles that brings about that clarity, of course, we're going to like. I think the reason we don't like it, there's a practical reason and a doctrinal reason. I think the practical reason with the proposal is that you're probably going to see a new front of Section 2 litigation over what any new test means and how it plays out on the ground. And so I think the upshot is the courts are going to continue to be inundated with Section 2 cases under this new test, if it exists. So as a practical matter, I don't know that we can...
What's the practical lack of clarity that you see? I guess I would have thought that solves a lot of the concerns that you've identified and that the amicus briefs that support your side have identified so far.
Yes, if I could answer that and then get to the quick doctrinal point.
Yes.
On the practical point, I do think that you start to see hints of this in the Robinson Appellant's yellow brief, the supplemental yellow brief, which is there's going to be a lot of disagreement in the lower courts about racial predominance. That is a critical trigger in a lot of this court's cases, and unless there's absolute clarity about how that analytical framework shakes out, then you're still going to see this onslaught of litigation that you see today in the Section 2 context. The doctrinal reason, Justice Kavanaugh, why we're not totally thrilled with the proposals. I think it's just a half solution to the constitutional problem, because at the end of the day, what the government's asking you to do is keep Jingles in some form, and as we've laid out in our supplemental briefs, Jingles 1, 2, and 3 are expressly built on the sorts of racial stereotypes that the court's cases say are impermissible under the Equal Protection Clause. And so I think that any test, whether it's good or bad as a practical matter, that at the end of the day is asking the government to assign voters to different districts on the basis of their race and is engaged in stereotypes about how members of a race, simply by virtue of their membership in that racial class, I think that's a constitutional problem, and so that's why it's not wholly fulfilling.
I think the reason they say we haven't really addressed their proposal before in our jurisprudence, in part because before Rucho, states wouldn't articulate that objective explicitly, and therefore it's an open question. Do you agree with that?
I think as a practical matter, that's probably true, Your Honor. I mean, I think pre-Rucho, states were going to be very hesitant to venture out to say, overtly, like politically, like here's what we're doing. And so that is, I think, a great explanation of why the court's cases have treated the political versus racial divide as it does.
And Chad, he's just pointing out that, yes, states have been terrified for a long time of redistricting and avoiding these lawsuits. Because since the 1980s, this has been the thing. So,
yeah.
But yes,
I'm also going to take my leave here.
Okay.
I still wanted to get to the gym. It's getting pretty late my time, so I'm going to go to the gym while I still have some energy left.
No, go for it, man. Go for
sleep. Well, but I've enjoyed hanging out with you. It's been fun.
Kurt. You guys find Kurt over at Uncivil Law. Kurt, we'll see you around, brother.
All right, man. I'll talk to you again soon.
Have a good night.
All right, bye-bye.
All right, chat. So let's get back to this. And yeah, we'll just keep going here. Guys, thanks again to Kurt for coming out. But we'll keep plowing through chat. We're not going all night, but we're going all the way on this one. So So Brandon, the anime guy, says, love the law talk. Well, yeah, this is a law channel, so I thought we should do some law talk. But we'll do some train stuff soon too, chat.
On common ground here, because I think it's always important in a case like this where there's disputes to identify what's common ground. Justice Jackson said the goal is equal opportunity for all Americans. I think we all agree on that completely. And the goal, of course, is racial non-discrimination. But at the same time, given history and given Congress's action, the goal is making sure that there have been sufficient remedies for the history of discrimination in the United States. And we've seen that in the school desegregation context.
And no, this is not a Sniper Elite channel. Well, we might do some Sniper Elite here coming up, chat, because I have been playing Sniper Elite 5, and oh my god, this is so fun. It is so cool. It really is the best, having played them all the way through, all the Sniper Elites. David, Making Law Simple says for $4.99, go all night. Well, if you guys ask nice enough, that could happen here. Brimstone, yes, it's perfectly acceptable to recognize that blacks vote based on race, but whites do not vote for a white politician because of race. Yeah, it's getting a little weird here. Let's see. Yes, if that's the case, KBJ should recuse herself since she's black. Very true. And J-Rock says, and listen to Iron Maiden, baby, with me. Ooh. I was saying the wrong part for a second. But there you go. Brandon, the anime guy, says, sounds like jingling those. And Hayden Harris says, yes, this is how you get your hash browns. Yes, cracked and packed and smothered and covered all the way and scattered all the way. Yes, Keopathic, yes. Sotomayor only ever talks about being a wise Latina. That's all she talks about. Correct. And then real quick, I am going to get to this here. We also have Jesus loves you for $2. Says, why are you streaming with Vito? Har, char, 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 char. Har, har, har. Let's see. I'm making sure I didn't miss anything. Going back through. Brandon, the anime guy, says, I am so tired of inferior courts and KB. It's KBJ, not KJB, but yes, it is shit. And you know what? Fair enough. It's like he's like, I don't even care. I don't have to know her name. Correct. Thank you. And then Hexy says, Yana, have you considered racism? Very true. Very, very true. Oh, very, very true. And guys, I catch up to everybody. It just takes some time. Hamster Eater 96 for $5. Does that mean you've eaten 96 hamsters? Or is it just you're the 96th person who identifies as being a hamster eater? Because if there's 95 of you out there, that's too many. That's too many already. I'm not sure, but that's once again, some of your guys' names give me pause to think. The left would see them dilate so much if the racially segregated Democrat districts got overturned because of this Mexican Solicitor General. Well, it's very ironic because the Mexicans and blacks fucking hate each other. Well, at least you have the Sureños and the in prisons at least. The Sureños and the blood and the white guys get together. Then you got in the other car, you got the Norteños and the blacks in another car. So yeah. Phone Punk says number 4 is just draw a circle around in. Once again, you're wrong. Guess what I'm going to determine, sir? The smallest word, the shortest word is the letter A. That is a word. A is a word. You fail. Even though technically you could be right. You fail. I determined you fail. So, once again, these are intended to fuck you over. Maddie B said, I don't see anything wrong with using these. It sounds great until basically you're voting in a situation where the other party is in charge of voting, or even worse, let's say you're a Republican, but you're voting for the non-Republican incumbent. You're challenging the incumbent. Or let's say you're voting for the incumbent, but the guy who's running, his friend is in charge of the polling location. Guess what? He determines you're illiterate. I want you to take this test. Sir, I have questions about your literacy. You say, well, sir, do I need to get the sheriff? Sir? That's the problem with these tests, guys. It's the problem with these tests. Yes, as Stabby points out, now instead of literacy tests, the Democrats just take your ballots and throw them in a dumpster. No bribes required. Very true. Sadly true. Vodka Blood for $2 says, good to see you, by the way. Just restrict the cages from voting and everybody wins. Ho, ho, ho. We just have to restrict all the people from southern Louisiana to vote. The guys in the north are the best. Like where Ag and EDW live, that's the best. Maddie B says, I prefer etouffee. EDW Raptor says, speaking of trains, you will like your 2-stream gifts. That train game is more your pace. Well, thank you, EDW. And then Hobby Cliv, I can't, maybe I butchered that, I don't know. Says, so is the argument they would only need Asian-specific districts, Latin-related districts, Arab minority districts, or is it only specific races? Well, remember, the only real minority in 1965 were black folks. I could see eventually Latinos becoming an issue, but even then, a majority of Latinos are going to the right, so the left won't fight that issue. And a majority of Asians are leaning more and more right, so they won't bring that issue up either. This is only for blacks. This is their way of controlling. This is how they preserve the plantation for the Democrats. This is how they preserve their plantation. So this is all about that. So, let me see here. Teenage Dirtbag is about Ricky Casso murdering his friend, then himself in jail. Wow, I didn't know that. Interesting. Brett Kavanaugh, why does that name ring a bell? That's Brewski Brett. Fallen Preacher says eating guinea pigs is okay, but you draw the line at hamsters. Well, I don't draw the line at guinea pigs, but we were talking about hamster eating. So Stacey says, I'm not familiar with Mexican gangs. Well, they started out in California. You have the Norteños and then the Sureños. That was kind of one of the big things there. Chugi shows, yes, Bianca Ellis, the black lady who murdered a 3-year-old child in a parking lot in Cleveland. Yes. Her trial, I'm going to see if there's any better feeds out there. We can go through it. I mean, it pretty much was a slam dunk. She murdered the kid in front of a bunch of people. But yeah, there we go. Ty says it's not a line if you close your circle, baby, but maybe I consider that a line. Let's see here. So let's see here. I don't know Louisiana geography. Well, I apologize, Ag, being the most native son of Louisiana. Unlike Iconoclast and EDW, who are complete fucking posers, I truly will defer to you on that. I truly will defer. So EDW Raptor is trying to claim, northern Louisiana says that's southern Arkansas. That's so funny. All right, guys, let's keep going here. Let's keep going. Real quick. Shredder S 07 for Ted Sobs. Let's fucking go tonight, chat. Big fucking support. Thank you, guys. Thank you. Oh, Sniper's Nest, good to see you, man. It's saying, I've come across an old Browns football from the 80s. Want it? I mean, I don't know. It's kind of, is it going to contaminate? Like, do we need more Cleveland loser memorabilia out here? Maybe. It all depends. I just don't want it to be generating more Factory of Sadness here. It's like radiation if we accumulate all of it together. Oh, maybe. But anyways, Shredder S, thank you very much for your support and your generosity. I appreciate it so much. Guys, if you got a sub from him, please tell him thank you. But anyways, let's keep going, guys. Let's keep going. We're wasting time.
In the college admissions context and a variety of contexts. And then Ms. Nelson, I think, suggested if there is going to be a temporal limit, she doesn't want one at all, but then I think she said if there's going to be one, there should be identified in advance. And I just want to get your response to that.
Our response to that is simple, Your Honor. Over 3 decades, dating back to Shaw 1 and Miller, the court has always qualified its voting cases with the caveat that racial stereotyping is bad, the 14th Amendment forbids it, and in all of that.
And yes, Louis went home.
I think anybody remotely involved in redistricting knows those caveats and has been on notice since the 1990s. And so, as recently as this court's plurality opinion in Schuette and then SFFA, where the court again reproduced that black letter law that racial stereotyping is not permitted under the 14th Amendment, the warning bells have been sounding for decades. And I think that's a long enough notice for anybody involved, Your Honor.
In response to Justice Kagan, Ms. Nelson said that black representatives and justices in Louisiana have primarily, if not exclusively, been elected in minority opportunity districts, and that the results would be terrible. You want to respond to that?
Sure, Your Honor. I mean, I think there's been a lot of sky is falling rhetoric from the other side in this case. And I just want to give you one political reality why I think that's a little overstated, which is remember that in a case, use a state like Louisiana, Republican legislature. If a Republican legislature wants to maximize its political seats, draw a 6-0 map, remember what has to happen with the hundreds of thousands of Democrat voters that currently exist in the majority Democrat districts, District 2 and District 6. They have to go somewhere. And that means that if the legislature wants to take the risk of maximizing, what they're doing is turning safe districts for high-profile political incumbents purple, and that I think is a very dangerous political risk. I don't know what our legislature would do if the court rules in our favor, but I'm just saying that's one political reality that makes me pause and say I don't think the sky is going to fall.
Thank you.
Justice Barrett?
Just have a clarifying question to see how I'm thinking about this and or the arguments that are being made. Would you say that Section 2, insofar as it goes beyond just intentional discrimination, because as Justice Kagan said, Congress amended it when we said that before, is itself an exercise of the enforcement power? Judge, I'm going to assume here that Congress's enforcement power is necessary and the congruence and proportionality test applies to Section 2. Do you agree with that conception? And I guess just to tell you where I'm coming from, I mean, it's one thing to say that the map itself is the remedy, but it might also be that the statute itself, insofar it goes beyond intentional discrimination, is the remedy. Is that a way to think about it, or is that how the arguments are going?
I think that's right, Justice Barrett. I mean, I think the court's precedents assume that if a plaintiff in a Section 2 case can prove up the preconditions and the totality of the circumstances, the automatic remedy, at least in this case, is going to be a majority-minority district. And I think the court's precedents assume that that is statutorily mandated. Like that's just the natural the consequence of a violation finding. So I do think it's built into the statute. Now, there was a lot of discussion earlier about whether we're attacking Section 2 itself, like facially, and that's just not true. The re-argument QP in our briefing has been focused solely on this use of race-based redistricting as a remedy. I think all the other applications of Section 2 that this court has considered remain fair game. If a plaintiff especially can show intentional discrimination, of course, that all remains fair game. But I think we're narrowly focused here on the use of race to draw district lines insofar as the court has understood that to be mandated by Section 2 to remedy unalleged violation.
So you don't understand yourself to be arguing that any part of Section 2 is itself unconstitutional, but simply as the way that courts have been applying it goes beyond.
That's correct, Justice Barrett. I mean, this court's precedents culminating in SFFA have said if the racial classification that a government's employing to allegedly remedy a violation is what's at issue, like that's the constitutional problem, and that's where we focused our briefing.
Thank you.
Justice Jackson?
So where in Section 2 does it mandate another minority district? I mean, my understanding, as I explored with Ms. Nelson, is that Section 2 is the mechanism by which we determine that equal electoral opportunity is not.
All right, chat, here we go. Big brain time. Big brain time. Get ready for this.
Not being provided for a certain minority group. And we've interpreted in jingles, we've given some flesh to how one goes about identifying that set of circumstances. But I thought that's the end of it in terms of the court's announcement under Section 2, and the court then turns to the state and says, how do you want to remedy this? We've got a problem. And sometimes the state might draw a second minority district. Sometimes it might not. And yet your answer to Justice Barrett was, well, everybody just knows that that's the automatic remedy. So can you help me figure out that disconnect?
Well, Justice Jackson, I think there's a reason why this court's voting precedents going all the way back to Shaw 1 are so tied up with race. It's because the remedy, as parties and the courts have understood Section 2 to operate, is almost always going to be race-based. That's why
they're so tied up with race because that's the initial problem, right? That's where that's the beginning. The beginning is the claim that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. That's the question we're here on today, but the Section 2 issue is just what circumstances do we look at to determine whether this problem of unequal electoral opportunity on the basis of race is occurring.
Right, and a couple of responses to that, Justice Jackson.
Wait, so can I just ask, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA, states can remedy intentional.
No, I'm not talking about the remedy. I'm talking about
identify.
Identify. All right. So if I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes. That you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step 0 in all of these cases, it was certainly step 0 in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No, it's not.
It is, though. And guys, remember, I told you. They said we're not having enough black districts. Our votes are being diluted. She's saying it's not the same thing. But how do you fix the problem, Justice Jackson? You don't fix the problem otherwise. The only way to fix the problem is giving you your black voting district. So how do we fix this? That's the only way to fix this. Yeah. She's like, that's not true. She's like, that's not true. It's like, but it is.
Far in your remedy is another issue, right?
Your Honor, I think step 0 in all of these cases, it was certainly step 0 in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second.
No, it's not, because again, just trust me on this. The second electoral or...
Trust me, I'm sorry, Katanji. No, I'm not trusting you on this one, honey. I am not trusting you on this one.
Second district is a remedy that one could.
I mean, Chad, I guess while we're here, we'll do this. We'll do this one.
That little NIGGER bitch.
I guess we'll use that right there. Technically, so there we go. Yes, if Reddit was a justice, yes.
Offer for a problem that we've identified, and the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see, I'm looking at the factors, I appreciate what you're saying, you've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right, and the problem, Justice Jackson, that the Middle District identified was not intentional discrimination. And in fact, I think
why do you need intentional discrimination to remedy a problem like the one that I identified?
Because if you're going to use race the way that the Robinson appellants want the court to use race in drawing a second majority minority district, you've got to have a compelling interest.
Thank you.
And thank you, Mr. Chief Justice.
Thank you, counsel. Mr. Grime?
Notice KBJ's like, yeah, owned. And everybody else kind of staring at her like, what the fuck are you talking? Remember, she's sitting at one end she's sitting out on the end. She doesn't get to sit in the middle. She's out on the end. When you're the new guy, you sit on the end. Everybody else is probably just staring at her like, what the fuck are you talking about? And she's like, yeah, I owned him, didn't I, guys? And they're like, okay. Oh. No, they all have looks of like, oh my God, she's so cringe. And then he's like, oh my God, she's cringe. Clarence Thompson's like, not this shit again. Alito's like, oh my God, she's retarded. Sotomayor's like, well, she makes me feel less stupid. Justice Kagan's like, oh my God, how did she get here? Gorsuch is like, I want to say it, but I can't say the N word. Kavanaugh's like, I'd like a beer right now. Comey's like, she should be cleaning somebody's house. And she's over here saying, yep, I showed them. But did you?
Mr. Chief Justice, and may it please the court. The appellees should prevail here.
And chat, remember, there's cases that have been consolidated, so there's multiple people arguing at once. And remember, they have to share their time in the middle to let the lady at the end try to save her ass with rebuttal. So here we go. This is another guy arguing in support of Louisiana and the second Black District.
Regardless of the grounds on which the court chooses to rely. In today's America, voters like the appellees are still being racially stereotyped to place them into single-member districts. If it was ever acceptable under our colorblind Constitution to do this, it was never intended to continue indefinitely. Section 2 effects findings alone can no longer justify the widespread stereotyping of American voters based on race in violation of the 14th and 15th Amendments. It is time to reach a question this court has never reached and hold that Section 2 alone is no compelling interest for racially gerrymandering citizens like the appellees today. The court should affirm and direct the district court to order a remedial map in time for the 2026 elections. I welcome any questions.
The last time we had this case, and in the materials that we have, there was quite a bit of discussion in the debate surrounding SB 8 that this district had to be drawn this way, the second district, because of the litigation earlier in the Robinson case. What's your view of the role of Robinson in the development of SB 8?
Well, it has exactly one point of contact, which is the state has admitted that it felt that it had to draw a second majority-minority district because of Robinson to avoid trial in Robinson. They did not want to have a trial during the time it was going to be scheduled, and so they passed the second majority-minority district, and they race predominated in doing that.
When you say race predominated, what exactly do you mean by that?
I just mean to apply the standard from Cooper and.
Well, I mean practically, how is it used in your mind, or in your thinking?
Well, basically the state went to the strongest remaining area of minority population, which was East Baton Rouge, and then they looked about the state for enough minority voters that was still contiguous to the main concentration in East Baton Rouge, and they went to the Northwest. And again, the goal that could not be compromised, which was a standard here, was that they had to draw a second majority-minority district, and that made the race predominate, both in the direction and in the details of how the lines were drawn.
Mr. Grime, you and the Solicitor General spoke about stereotyping and how there's no place for stereotyping. But I'm wondering what stereotyping has to do with any of this. The requirements of a Section 2 vote dilution claim are essentially that there's residential segregation by race. That's not stereotyping. That's just where people live. And that there is racial block voting. Essentially, that whites won't vote for a black candidate. That's not stereotyping either. That's just what the data shows about racially block voting. So I'm wondering how it is that stereotyping gets into this case at all.
Well, Your Honor, two points. First of all, stereotyping is the remedy that occurs when race predominates and is used to sort voters into one district or the other. And the reason that's important is to go back to the second kind of predicate to your question. In a jingle showing, the showing that's made is not that white voters or majority voters won't vote for the minority candidate. The only showing that's currently being made is correlation. And so what we're not seeing in cases today is a showing that we can separate out partisan politics, any partisan motivations that the majority or minority voters have. And so that case could come along, but that's not part of the required showing of jingles the way courts are applying it.
Well, I think that, we've had several cases up here where we've acknowledged that there's some interaction between race and partisan affiliation. Obviously, that's right. And the task for the courts is to separate those things out, which may be hard in a given case, may be easier in a given case. But the only thing that's
Chad, I'm listening. I'm on the phone with 2.0, so you guys, I'll be back.
Again, You know, it's just a there. There is currently, in order to prove a Section 2 violation, you have to show that the current conditions, not some old conditions that happened in 1962 or in 1982, but the current conditions are such that there's no equal opportunity for African American voters or some other group because there's racially blocked voting. And I guess I don't see what this, where stereotyping comes into that. It's just there's a there that African Americans can't elect candidates of their choice.
Well, the problem, though, is in the remedy. The problem is that when you are drawing your remedial district, which is the very first part of Jingles, I mean, that may not be the final district you end up with, but just to reach, I'm covering your question and a question Justice Jackson asked. The very first thing the plaintiff shows is here's the community that was cracked or packed. And so to undo that, you have to look at the race of the voters all around that area, and you've got to make assumptions about them based on statistics, but you've got to make assumptions about what they think and how they vote based on their race, and you're drawing new districts based on that.
Yeah, I mean, this is the thing that we decided in Milligan, because what the state said in Milligan was that the plaintiffs could not use a map that was at all race-based themselves in order to show that there was a way out of this kind of vote dilution, these kind of vote dilution practices. And the court said, of course you can do something that is race-based, even though not race predominant, that we're not going to insist that you come in and ignore the factor of race when the only reason we're here is because race has played such an integral part in the voting process that people are being deprived of their voting rights because of race.
Well, Justice Kagan, the plurality in that section of Milligan drew the line between race-conscious and race-predominant districting. Race-based appears, and maybe we need to define all of our terms, it appears in the decision. But I think what is clear from that case is that the remedial maps can't allow race to predominate. I mean, the court said that the remedial map, the illustrative map, can't violate the court's redistricting decisions. And of course, there's the entire Shaw line.
I don't think that there's any dispute as to that point, but you know, we're a long way from racial predominance to have the plaintiffs come in with a map that, in order to remedy the race-based problem that exists, the violation of voting rights based on race, itself takes race into account.
Well,
that's what Milligan said 3 years ago.
The problem, I mean,
and that wasn't a stereotype issue, and it wasn't a kind of like we're based on past conditions issue.
Notice Kagan is starting to step on her dick a little bit, but Ketanji Brown Jackson goes, "Watch this, I'll stomp on my dick." But yes, we're getting into the good stuff now. We're getting into the good stuff, shit. Here we go. It's only going to get better.
Based on current conditions, which is that we just proved a violation of people's voting rights based on current conditions.
Stereotyping is always the main injury in a Shaw case. It's always the injury when race predominates.
But you're asking for changes to Section 2, which is not the Shaw case. That's the confusion. I understood that the illustrative maps that the plaintiffs bring in the beginning of a Shaw case is part of their showing that we have a problem. They're illustrative. They're not what Louisiana picked in this case. They're not what the court requires. The court gives the state, once the violation is established, the opportunity to draw its own map. So they're just showing, like that's just a step that you have to do as a part of your showing that we do have this vote dilution problem in this situation. And as Justice Kagan says, that's all based on current information.
Well, but the question is, what's that is based on current information? It's not a showing of intentional discrimination.
Why does it need to be? Is your suggestion that the only thing that's worthy of remedying is the intentional discrimination by the state?
If you are...
Yes! That's the only thing that should be remedied. If there's no discrimination, what is there to fix? If there's no discrimination, what is there to fix? I mean, for real. For real. Like, what is there to fix otherwise? What is there to fix otherwise? What's there to fix? I don't know. Like, I don't know. Like, why do we have to fix anything? If there is no more racism, who gives a shit? I'm just saying, chat. I'm just saying. Yeah. Yes, yes, Missouri Battle Flag. This happened in real life. Was really happening. This is really happening. Kathy, your realtor living in New Jersey. Guys, remember, buy, sell, rent, lease. Whatever you're doing in New Jersey and involves real estate, Kathy is your realtor to go to. She's saying, why isn't Roberts jumping in? Because they don't feel like maybe they're waiting for their time. They try to let justices get through a round of questioning first. But they kind of go in order. So eventually he will have some questions here. But remember, this guy and Roberts probably agree. Actually, this might be a 5-4 with Roberts going with them. But overall, I mean, he'll get to it in a second. But Roberts has talked, but he doesn't necessarily have to. He hasn't asked a lot on this one, but he's not in charge on this one. So Alito and Clarence Thomas are really in charge on this one. So, but anyways, Kathy, thank you for the $10 super chat. I appreciate it. Hope you're doing well tonight. So yes, accidental discrimination. Well, Crozen, we talked about this before. It's the idea of disparate impact, where you have a neutral policy that ends up creating a discriminatory result. There's, disparate impact. And that's what she's arguing here should count. So we'll see. We'll see, though. Let me see here. Shredder S says the best gift of Sean remembers I'm a dude. Much appreciated. I'm sorry, but for some reason I thought you were a chick. And Stabby says my case of 45 came in today and my 2311 should be here tomorrow. Hopefully my background check doesn't take forever. No, may you get no delays. And have fun with that. Let me know how that shoots. I'm curious to know. Let's see here. Jose says for $5 in a literacy test on line 3, you wrote a line through the longest word. It said, cross out the word. An X, a cross is an X. Get to the back of the bus. Maybe, but a cross is not an X. An X is not a cross. Maybe you have to draw a Christian cross. But I agree. There's all kinds of rules. Brandon, the anime guy, says my IQ dropped listening to this. Yes, I don't. Trust me. And Johan says 13% of the population, but they want their own districts. 13% of the population, but he lived in 100% of the White House. KLF's been a better for 10 months. Thanks, Kay. Says, answer your phone 2.0 wants to go to bed. Yes, I took care of that. Yes. Stephen Cooper says, make sure 2.0 brings home some Coors and a pack of Winstons. I mean, if she brings home some Yellow Jackets, I'm not going to be opposed to that. I'll drink some yellow. You know what? Maybe I'll do that for Friday. I'll go pick up some Coors, but I'll pick up we'll get some yellow. We're not going to do Silver Bullets. We'll do some Yellow Jackets, the banquet beer for that on Friday. And Spudgun says, I want to make sure I'm following. Basically, want to combat racism with more racism. Yes. You can use racism to remediate the problems of the past. You penalize people who had nothing to do with it to remedy the effects of what evil people who are long now dead have done. But you penalize innocent people to make up for it. Yes. Yes, it's all about, it's retribution. But yes, now you're getting it. Connie Desquad for $5 says, this entire case makes me hate Lincoln and the Union more. Yeah, I understand that. Yes, very true. Very true. So let's keep going here. Let's keep going, chat. Yes, it makes you more racist. Yes. Jay Cases, just watch out for Smokey when you go get those Coors. Yep. You got to be careful. Got to be careful, man. If you're if you're east of the Mississippi. Not the Yellow Jacket trucker pills. Well, no, but the modern Yellow Jacket, the Yellow Jackets now aren't as good as the Yellow Jackets back in like 2000. Like those Yellow Jackets were the ones you could take where you thought you might have a heart attack when you used them. Those are the good Yellow Jackets. All the ephedra and shit in them. Those were the good ones. I drink Bud before I drink Coors. I mean, like, yeah, I prefer Bud. I'm a Bud guy, but I'll drink Coors. There's nothing wrong with that. Nothing wrong with it. Yes, the sins of the father. Yes. Whereas the Germans would say Siepenhaft, the punishment of the guilt of the family. Rando says, can we put, and somebody want to say Baton Rouge. and Nolens and Shreveport in the same district and call it a day. Remember, the district has to be contiguous. You can't have breaks in it. But yeah, you might end up with that at some point. No, when I say Yellow Jackets, Edward, I'm talking about so like most people when they think of Coors beer, you think of like Coors Light, the Silver Bullets. But there's also like Coors, like there's just Coors. And before there was Coors Light, there was just Coors, and they came in a yellow can, and like it wasn't like yellow, but it was like yellowish, and that's why they were called Yellow Jackets, because they had a yellow jacket on them. Yes, they were the banquet beer. Stacey says, drink the light. Well, that's at least drinking light beer versus regular beer is like smoking a light cigarette versus a regular cigarette. So, North Korea only punishes 3 generations. Well, that is true. That is true. So, Miller also has yellow cans. Yeah, but nobody ever called Miller Yellow Jackets. So, around here they're called Yellow Bellies. I've heard Yellow Jackets. That's what I heard. Not a lot of people drank Coors like in my area. Most of the time you just had, and I think for the longest time it's Smokey and the Bandit's a true thing. In 1978, you were only finding Coors east of the Mississippi if people were running it. There wasn't any distribution of it. It was only Coors Light. So light beer has less alcohol. When I drink beer, I prefer Coors and Miller. Oh, God, I cannot stand Miller. Man, Miller makes me barf. I mean, drinking MGD, man, I had a nasty blackout. That was really rough. So I stay away from Miller. It makes me just, ugh. So. I prefer agave tequila. Yeah, I understand. I am not a fan of the low life. I cannot drink the low life anymore. So let's keep going, chat.
Or if the remedy is stereotyping and race-based.
Set aside what the remedy is. I just need an answer to the initial question, right? If looking only at Section 2 world, we have a mechanism for identifying race-based vote dilution and other kinds of problems. Is your view that you only are entitled to some remedy for that if you demonstrate that the state intentionally is causing this to happen to you?
Well, that's not current doctrine under Jingles, but the problem is
that your argument? Is that what you're saying we have to do?
Our argument is that if you're going to allow a race-based remedy, it must be in response to intentional discrimination.
So you don't get a remedy for an actual dilution or problem with your vote, the kinds of things that Congress cared about and that the Constitution requires. You don't get a remedy unless this was intentional on the part of the state with respect to you.
Which is a constitutional vote dilution claim, which people always can be bringing.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
So I'm assuming that the ban on poll taxes, literacy, well, not poll taxes, because those have been eliminated by the 26th Amendment, but that the literacy ban that we have will sunset too?
No, those are not those remedies don't require racial stereotyping.
Well, they do, because to prove them, you have to prove that it affects the races. I mean, I just don't understand the stereotyping concept.
Remember, that's not true because white people could be subject to it as well. So Sotomayor is wrong again.
In the Jingles factors, the Jingles factors is looking at whether these people have their vote is being diluted or if their vote is being taken away from them merely because they're black. And so if that's the case, we have always said that remedying a discrimination, you can use race. Now, you want to add the qualifier, it has to be intentional. But I don't see the 15th Amendment being limited that way. The words of the 15th Amendment are that Congress can stop any practice that dilutes voting. Practice is an act that has an effect. It didn't say intentional dilution of voting. The amendment itself talks about a practice.
Your Honor, this court has never held that the 15th Amendment addresses anything other than intentional
No,
discrimination.
that's just not true. We, just in Mulligan, and we've said in a slew of cases, Congress itself said, we're not using intent, we're using effects. And we said that's okay. That's within their power as specified in the 15th Amendment.
But Your Honor, you can only catch the effects as part of an enforcement. That's just the enforcement power at that point. So you're using the enforcement power based on a showing.
Discrimination is the practice.
The case law going back to Katzenbach and
Mr. Ryan, I mean,
I'm sorry.
are we?
Yes.
Sorry.
Justice O'Connor.
Well, I'll stop and you pick up.
Justice Kagan.
Sorry.
No, you're not done.
I'm in no hurry.
What we've said, and this goes back umpteen years, and it was said again in Milligan, is that even if the constitutional prohibition is one on purposeful discrimination, Congress can enforce that prohibition under Section 5 of the amendment by way of prohibiting various kinds of effects. And so in Milligan we said a ban on discriminatory effects is an appropriate method of promoting the purposes of the 15th Amendment. And as I said, that goes back to Katzenbach, it goes back to City of Rome. And I understand that common ground here, including among the SG, is essentially a desire to take us back to an entirely intent-based world. But that is, that is the thing that we tried to do, that Congress prevented us from doing, and that since the amendments of 1982 has been very clear that that you do an effects test for Section 2 in order to vindicate the purposes of the 15th and 14th Amendments.
It's clear what Congress did. I mean, but it was using its enforcement power only. It doesn't have the power to change.
I mean, I'll take that label. That's fine.
But
Congress has enforcement power under the 15th Amendment.
But it was not an appropriate use of the enforcement power, and even if it was then, it's not appropriate today because it's not congruent and proportional. And the court has never held.
And what is this kind of? Was it congruent and proportional in 1982, or is it just like suddenly not congruent and proportional because it's 40 years later? Like, I never understood our congruence and proportionality test, which, by the way, we have never applied to voting. But even if you were to apply it to voting, I've never understood it to have a kind of, Congress has to re-up its congruence and proportionality findings every 10 years or every 6 months.
It doesn't, but shouldn't it? If we're going to have such a massively powerful act that can alter how governance is conducted in this country, that it can affect Congress, like what we just, because otherwise, if we just use the metric of, well, black people were getting fucking fire hosed and bitten by German shepherds all the time, like, shouldn't we reflect on that things have gotten better? Things have changed? No, we're stuck in analyzing everything from 1965. And then in 1982, it jingles. Shouldn't we change that a little bit? Shouldn't there be a little bit of Remember, this is kind of where we get to that point of, well, how will we know when it's fixed? Well, we'll tell you. Yeah, that's the thing. Conditions change over time. Correct. Yeah, no, we should pass laws and never measure their effects. I agree. Make fire hoses. You mean fire hoses. Yes, it'll never be fixed. I agree. Yeah, people still bring up redlining. I know. That was more rhetorical than anything. So, more rhetorical than anything. And Great Loader, you're correct. Aren't these lefties always the ones screeching about the living document? Yeah, here's the thing, though. That living constitution argument, Ryan Mullally kind of summed it up best. Yeah, that kind of died a while ago. That died a couple years back. That kind of died a quiet death because everybody kind of, like, it just lost steam. But yes, for a long time they just call it a different name now. Yes, and fun fact, redlining affected more poor whites than blacks. Yes, 100%. 100% it did. It was very devastating to everybody. So, but yes, let's keep going here.
Or every whatever you want to say it.
Well, City of Bernie, and that decision holds up Katzenbach and City of Rome as sort of paradigmatic exercises of this sort of scrutiny, although they're much older. But the point is this: those cases were based on a strong factual record about very particular effects-based prohibitions that had just been used for purposeful discrimination. They were using poll taxes and literacy tests, although facially neutral, to purposely discriminate, and they would keep changing them over time to make sure that they kept the discrimination in place. So that was a very unique circumstance, and Congress recognized that in 1982. It said, we don't have the same kind of record that we built in 1965 under Section 4A to get rid of a literacy test in a certain area, or when we expanded that out in 70 and 75. People were actually using literacy tests, and they were using them in a discriminatory fashion. So but none of those remedies stereotyped.
Thank you. Justice Gorsuch? Justice Kavanaugh? Justice Jackson?
So going back to this discriminatory intent point, I guess I'm thinking of it.
And she's like, let me put back on my retard suspenders. I'm going to wade back into this.
Of the fact that remedial action, absent discriminatory intent, is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with
Here we go, chat. Here we go. This is like, wow, she's really going to fucking say it. Here we go. Here we go, chat. This is, oh no. Yes. Oh no, not this. We're like, oh yes. Can we get 50 subs in the chat to hear the most retarded thing ever a Supreme Court justice will say?
Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open. So I don't understand why it matters whether or not the state intended to do that. What Congress is saying is if it is happening, which Section 2 gives us the tools to determine, you got to fix it.
The difference is that the remedy under the ADA and other anti-discrimination laws is not stereotyping. We don't then.
It's not race-based. I take your.
That's it, chat. Being black is like being retarded. There you go. It's not even disabled. It's being retarded. Yes. Why is Russell Greer law relevant here? Is she saying Russell's black? Is she saying if you're retarded, you are black? It's like, no, Chet, I don't want... Wait, I can't like trains anymore. No! No! This is not good. This is not good. I do not like this. No. No! So, yes. Yeah, you're like, yet when I say it, I have to go meet HR. Yes. We're all black now, chat. We can now say we all have N-word passes. Yes. Yes. We was conductors and shit. Squizgar says, wait, KBJ said something was true. Well, yeah, but also remember, Thomas Sotomayor says that black women are retarded also. So maybe she's right. Maybe she's right. So, thank you for the super chat. Let's keep going, guys.
I take your point. But you're saying then that if the problem of no access is about race, it's just too bad because you can't have a remedy that relates to race.
Absolutely not, Your Honor. It's not whether it relates to race. It's whether the remedy that relates to race involves stereotyping voters and making assumptions about their politics and their views and their thoughts based on their race, and that's the problem. It doesn't exist in those other
So why do we have to change Section 2? Okay, so fine, you say if it's a remedy problem, why aren't we just focused on whether the remedy here, the particular map in Louisiana, is predominant, using race, and if so, strict scrutiny applies, and did they narrowly tailor it? I mean, that seems to me to be the problem that you're identifying. The remedy here, you say, is overbroad. It's not using the right factors. It's using race in a stereotypical way. What does that have to do with Section 2 and changing its criteria and adding intent there?
Well, Your Honor, you have to break the link between only using effects on the front end and on the back end using race and stereotyping. That's what you have to break. And so, I mean, this court warned about that problem.
Okay, I don't see the link, but I'm out of time. Thank you.
Thank you, counsel. Mr. Mupan?
Mr. Chief Justice, and may it please the court. I think this court's predominant standard will help clarify a lot of the issues that have been discussed this morning, and will also show why the arguments we're present here were neither raised nor rejected in Milligan. So first, under the Constitution, the problem is not the mere consideration of race in districting. The problem is when race subordinates traditional neutral principles and is the factor that cannot be compromised. Second, the problem with Section 2 and Jingles is not that it's an effects test. The problem with the statute is, as construed in Jingles, it's reaching far beyond anything that can reasonably present a risk of intentional discrimination, as in fact making race predominant. It is requiring states to subordinate their principles to find a result. The Robinson litigation perfectly exemplifies this. The Robinson plaintiffs could not show a denial of equal openness for black Democrats. What they could show is that Democrats in Louisiana lost a seat. I welcome this court's questions.
In one of your suggestions,
That's right, EDW, yes. The state of Louisiana sent in a Mexican guy and an Indian to go knife a black woman on the Supreme Court, to go knife opposing counsel. We didn't need to send in white people to take her out. So, yes, I'm sure he's heard the Moops joke more than once.
in your brief, you mentioned decoupling race and party.
Also, chat, Deputy Solicitor General, I believe he's Deputy Solicitor General for the state of Louisiana, just like the Mexican guy was earlier.
One, is there a correlation, particularly among black voters? And two, how do you decouple them?
So there generally is. The way you would decouple them is you look at primary elections, right? You look to see in the Democratic primary, do white Democrats and black Democrats vote differently? And that did not happen here. If you look at the Robinson District Court opinion, when they do steps 2 and 3 of Jingles, and they analyze racially polarized voting, the court expressly said they didn't need to try to decouple race. And they did that because in Jingles, the court never resolved the issue. Justice Brennan said you didn't need to do it, but Justice White refused to join that part of his opinion. And so that's part of the problem here, is that what's going on under Jingles now is it's not actually figuring out whether there's an unfair effect based on race. It's figuring out whether there's an unfair effect based on party. And again, the Robinson case perfectly illustrates this. Justice Alito, as you pointed out, incumbency protection has long been recognized as a traditional race-neutral principle. While the plaintiffs' illustrative maps in Robinson totally departed from incumbency protection because every map they provided would take the state from a 5-1 map to a 4-2 map and require displacing some Republican incumbent.
Counsel, and Justice Kavanaugh pointed to page 2425 of your brief as well. We didn't grant cert on redoing Jingles. We granted cert on a totally different question. And we have said over and over again that statutory precedents are entitled to far greater stare decisis protection. Whatever mistakes we have in Jingles, Congress has had 40 years to fix them and it hasn't done it. In fact, when they thought we did something wrong, they overruled it and passed Section 2. I don't know how we get to redo Jingles when this case didn't involve Jingles. The district court in this case didn't apply Jingles. It was a district court in the Robinson's case, and it's not the Robinson's case that's before us, it's this case. And so I'm a little bit confused. How do we enter redoing Jingles?
So the reason you're there is you asked two questions. One is why it's relevant, and the second is can you do it under stare decisis? So let me address those in turn.
You can do it in whatever order.
Okay. So
tell me, did the district court here apply Jingles?
No, because this case comes up as a racial gerrymandering case brought by the Callais plaintiffs. They showed that race predominated.
But that has nothing to do with what the court did here.
It does. The reason it does is because once they showed that race predominated, the burden flipped to the Robinson appellants to show that they had a compelling interest.
Right.
They asserted the compelling interest with Section 2, but if they misapplied Section 2, then they don't have a compelling interest.
But we have said over and over again that the compelling interest is in a state believing that it should remedy something, and it can be wrong.
Not as a matter of law,
We have said that over and over again. Counsel, you're wrong sometimes on a factual basis, sometimes on a legal basis. Wrong is wrong. Whatever you think might be the error, if you still think that it's something that's in your best interest to do, you do it.
Your Honor, that's contrary to this court's holdings in Miller, in Shaw 2, and in Cooper. This court has repeatedly said that if you have an incorrect reading of Section 2, or Section 5 of the Voting Rights Act, that is not a compelling interest. The court has applied the good faith standard under strict scrutiny to errors of fact, not errors of law. In Miller and Shaw, the DOJ browbeat states into creating multiple majority-minority districts, and they all thought they were doing it under Section 5. They were acting in good faith. The DOJ was browbeating them. But this court said that is not a compelling interest because the DOJ was wrong about what Section 5 meant.
That hasn't been the allegation here.
That is the allegation here. The allegation here is that the Robinson court was wrong about what Section 2 meant. They completely misapplied Section 2, even actually under Milligan, let alone under the proper way to interpret Section 2. Again, Justice Alito, 3 points. First, they ignored incumbency protection. If you look at what the district court said, they said they protected incumbency because Julia Letlow could still live in her district. She would lose, but she could still live there. That's not incumbency protection. 2, they did the exact thing that this court held in LULAC is not a compact district. As you said, they took blacks from Baton Rouge and blacks at the north of the state and jammed them together. Yeah, it's a nice rectangular district. It's very pretty, but it's not compact. And then third, they didn't control for racially polarized voting. So they just said that blacks vote differently from whites, which just basically means Democrats in Louisiana vote differently from Republicans in Louisiana. That's not racially polarized voting. That is not the proper interpretation of Section 2, and it is exactly why Section 2 is leading to racially predominant results, where you're essentially using Section 2 to undo political outcomes. And that is an unconstitutional reading of the statute. And so the reason to get to your first part of your question, why should you revisit Jingles? Because we don't think it's consistent with stare decisis to say, well, we misinterpreted the statute 40 years ago, so now the statute's unconstitutional. Stare decisis is about respect for Congress and respect for stability. If this court has created a constitutional problem in the statute, this court should fix it.
Can you say?
And that's correct, guys. Stare decisis is not a suicide pact. And he's correct. If the Supreme Court has caused a problem, they have to fix it. Just saying, well, stare decisis. If it's wrong, and that's the thing. Even if it's wrong, stare decisis isn't an excuse. If it's wrong, and it should be fixed.
More about why there's a constitutional problem with the statute.
Yes. So, as I was saying, the problem here is Jingles, as it's been interpreted, essentially imposes liability based on making the state take race and predominate over race-neutral criteria. Again, using Robinson as an example.
I don't understand. I'm sorry.
So, incumbency protection is a traditional neutral principle. Robinson found liability by requiring the state to discard their race-neutral.
But I thought you said Robinson was wrong, so then we just changed that understanding. Why does that create a constitutional problem?
So no, it's the way it was wrong is it required the state to subordinate race-neutral principles to race. And let me use Milligan.
And we say Jingles requires that.
So the way.
So it was consistent with Jingles, and Jingles is wrong, or it was inconsistent with Jingles, and we should say that.
It's the interpretation of Jingles that was adopted in Milligan is the real problem here. And so this is the pages in our brief that Justice Kavanaugh cited a couple times. The fundamental problem is when this court said in Milligan that as long as the plaintiff's illustrative map is roughly equivalent to the state's map, that's enough to satisfy Jingles. What that meant is you're basically telling the state that you have to subordinate your weighing of your neutral principles and go a different direction just because of race. Let me give you an analogy that I think will make this a little bit clearer. Imagine if Congress had passed a statute that said LSU, if you have a white student and a black student who are roughly equivalent on your admissions criteria, you must pick the black student. Of course that would be unconstitutional. That would be subordinating.
Yeah, but do you agree with my view that under Section 2, you're not alone mandating a particular result? That Section 2 is just about identifying the problem.
And I agree with that.
If that's the case, then it doesn't matter that the Section 2 analysis is showing you that there could be another way to do this.
It depends what you define as the problem. And the problem with Section 2 as construed in Jingles and Milligan is they are defining as a problem that there's another way of drawing the district that would help blacks, even though there's no reason to think that it's either intentionally discriminatory or even a significant risk of intentional discrimination.
But why is intentional discrimination the bedrock? They're not just, you're reducing what is happening to Section 2 to something that I don't think is consistent with what Jingles is actually requiring.
Because the Constitution prohibits intentional discrimination, and Justice Barrett, as you pointed out, this is enforcement legislation. So we agree it's not an intent test, but it has to at least be smoking out conduct that presents a significant risk of intentional discrimination. That's the phrase that this court used in Bernie, is the phrase that this court used in Katzenbach too. Again, one way of thinking about this is if you think there's a problem here, white Democrats in West Virginia, they don't get districts drawn for them. White Democrats have zero representation in West Virginia, even though they're a significant percentage of the state. The reason why Section 2, it's being construed in Jingles, is a problem is it's saying that you have to create a district for black Democrats that you would never create for white Democrats in a Republican state. It's essentially being used as a reverse partisan gerrymander on purely racial grounds. And that is a constitutional problem. And the test we have identified in our brief would solve that problem.
Thank you.
Thank you, counsel. You began, if I'm remembering correctly, suggesting.
Absolutely correct. Flawless victory there by the Deputy Solicitor General, by Hamish. Absolutely flawless.
That Milligan was consistent with your position in this case. And then, of course, you've mentioned its discussion of Jingles is not. I wonder if you could explain that a little further, to what extent it's consistent and to what extent it's not.
Yeah, so most of the arguments we're making in this case were not made in that case and were not rejected in that case. There is one aspect of our argument that is inconsistent with Jingles, with Milligan. The one aspect that's inconsistent is what I was discussing earlier. The part of Milligan where it said that it's reasonably configured so long as it's roughly equivalent. We think that that is wrong, and we think that that aspect of the opinion is what causes all the racial predominance. Because again, if you take a step back and think about two possibilities. Possibility one is the plaintiffs come in and their map is superior to the state's map on the state's own principles. Then we think it's okay to have a results test, because in that circumstance, you're not telling the state they have to subordinate their race-neutral principles. You're essentially enforcing their own race-neutral principles in a situation where there is either intentional discrimination or at least a significant risk of intentional discrimination. But conversely, in a situation where it's equivalent, you're basically telling the state, look, you could have done this either way. You want to do it way A, you have to do it way B. Why? Only because of race. That's what makes it predominant. And that's the one aspect of Milligan that we disagree with. But
Thank you. Justice Thomas? Justice Alito?
Well, I think you may be too hard on Milligan, because Alabama and Milligan did not argue that it had drawn those maps based on seeking partisan advantage, right?
I agree, right? And that's why I started my answer to the Chief Justice by saying all the arguments we were making here were not made by Alabama. Alabama made a series of much broader arguments about how you can't consider race at all, the plaintiffs have to draw their maps race blind, you ultimately have to find intent. We're not arguing any of that, and I agree with you, Alabama, for whatever reason, didn't argue that incumbency protection and partisan advantage were the reasons for their map. And after Rucho, it's clear that those are traditional race-neutral principles that cannot be subordinated by Section 2.
Yeah, and I think that's consistent with the fundamental analysis in Milligan for reasons that I tried to bring out during my questioning of Ms. Nelson. The first Gingell's precondition, as described correctly in Milligan, is that the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district, and a district is reasonably configured if it comports with traditional districting criteria. And since Rucho, seeking a partisan advantage is a permissible legislative objective, just like incumbent protection. So therefore, that should figure in the first Gingell's precondition.
It absolutely should. And in this case, in Robinson in particular, the state did argue incumbency protection. And if you look at what the Robinson District Court said, it actually said that, oh, we satisfied incumbency protection. She still lives in the district. She's going to lose, but she still lives there. That can't possibly be right.
And then again, on block voting, again, the Rucho issue was not involved in Milligan, but if block voting is understood properly to mean voting on the basis of race but not on the basis of partisan politics, then that must also be considered under Gingell's, right?
Absolutely. And it matters, right? Because on our position, again, we agree that Section 2 can have a constitutional scope, and our view of the results test would apply in exactly the situation where racially polarized voting properly understood exists. So think of an area like Harlem, for example. You've got white Democrats, black Democrats, and Hispanic Democrats who all live around the same area, and who probably have, at least sometimes, different candidates of choice. If the state of New York were to draw a map in a way that departs from their normal principles and favors one of those racial groups, that's the sort of situation where Section 2 could come in and say, well, there's racially polarized voting, you've departed from traditional principles, there's a reason to be worried. And this isn't just a partisan thing. You can imagine the same thing on the Republican side. Imagine Florida. If you have a part of Florida where you have white Republicans and Hispanic Republicans, and same thing, the Florida legislature draws it in a way that departs from traditional principles and favors one or the other racial group. But what you can't have is merely just showing that a Republican legislature favored Republicans with whether or not they're white or black. And there's just no reason in the world to think that the Louisiana legislature would have done anything different in this case if every black Democrat in Louisiana was a white Democrat.
Let me ask you about congruence and proportionality. So the 15th Amendment pretty clearly requires intentional discrimination. And the 1982 amendment to the Voting Rights Act walked away from intentional discrimination. But my reading of your position is that Congress's enforcement power under Section 2 of the 15th Amendment allows it to go beyond intentional discrimination for this reason. Proving intentional discrimination is difficult in part because it's really hard, it's always hard to figure out what legislative intent is. What was the intent of the legislature in enacting a map? Do you look at stray statements here or there by legislators? Plus, a finding intentional discrimination accuses the state of a serious wrongdoing. So it's permissible to go beyond intentional discrimination to this extent, to identify factors that strongly support a finding of intentional discrimination. And that's what was involved in White versus Register, which figured very prominently in the drafting of the 1982 amendment. So to that, if that's what you're doing, it is congruent and proportional in that respect. Is that a correct understanding?
That is, and if I could just amplify a couple of points. So we agree, the Constitution prohibits intent. Congress's enforcement power can let them go beyond that to, in effect, test a properly tailored one that gets at a significant risk. And that avoids a lot of the difficulties of actually having to prove intent by a preponderance of the evidence. And if it is actually tailored, if the statute itself is tailored to things that have a significant risk, then we don't actually think you necessarily need to have a temporal limit in the statute itself. So that's why, Justice Sotomayor, for example, the bans on tests, literacy tests, we think those are fine, even though there's no end date in that statute, because those are well-known, highly likely to be intentionally discriminatory laws, even if they're not always. But the problem we have here is that the way Section 2 has been construed under Jingles and its progeny is so far from the things that are likely intentionally discriminatory, and indeed are affirmatively compelling gerrymanders that are unconstitutional. If that is ever permissible, it could only have been based on the centuries worth of discrimination that existed in 1965.
One final question. I'm sorry to take up so much time, but I would like you to address what Solicitor General Aguinaga said about the practical problems he fears your approach would.
And chat, this guy's got it easy. He's got 6 justices who are just riffing along with him. So, and then he had another justice refer to black people as retarded, and he's just like, I'm sure he got done and was like, he got him and his buddy were both sitting there on the steps of the Supreme Court, like, what the fuck just happened? Because that's how I'd feel right now if I was him.
Would cause.
So I'm not sure I really understand what his concerns are. I think the way we've articulated the test, the plaintiffs have to come in and show that they have a map that is superior to the state's map on the state's own race-neutral principles, including its political objectives. I think the thing that the Solicitor General primarily focused on is confusion about what it means to be predominant. I think we agree completely with them that the phrasing of the standard is race a criteria that could not be compromised? Have you subordinated race to traditional principles?
Chat, I'm sorry. I'm pretty sure this guy's actually from United States Deputy Solicitor General, not the Louisiana one. He's from the United States DOJ.
And if you apply that test, I'm not saying that there won't be difficulties on the margins of how to apply it. There will be new cases. You know, Your Honor wrote the opinion for this court in Brinovich. It was the first time that the court had ever adopted the test for vote denial under Section 2. I'm sure there were cases afterwards, but that test was well tailored to the text of the statute and its purposes. And what we're essentially saying in this case is you should do to Section 2 as opposed to vote dilution what the court has already done as applied to vote denial. It should adopt a test that's tailored.
Thank you.
Justice Sotomayor? The bottom line is just get rid of Section 2, because the test you're providing doesn't do anything for the effects test that Congress identified. We did say in Kassenbach, we've said it repeatedly, that legislation need only be plainly adapted to addressing discrimination practices in voting, right?
Yes.
All right. The standard that you're setting is a much different one. It has to substantially be addressing this issue. Number 2, what you're suggesting is that people of one race, blacks in Louisiana, who will have to be
Guys, and remember Hermie Dillon, you know, she's worked with the famous, the world-famous and world-renowned Ron Coleman on multiple things. Now is in charge of Civil Rights Division in the DOJ. And yes, he's been involved in this action here. So, yep, here we go. And here's Sotomayor going after him.
51% of the population before they'll be able to elect another black candidate. Because what you're saying is partisanship is non-negotiable. You have to create maps where you're going to have 6 districts out of 7 always white, because that's our partisanship. That means blacks never have a chance, no matter what their number is, until they reach more than 50.
Chat, we need a clipper. Blacks will never have a chance. Like, whoa. But she is right. They'd have to be 61% of the population before they could do it again. Oh, well.
51%.
So I don't think that's true for a lot of reasons, Your Honor. So the first is, as I think the general pointed out, even without Section 2, there's no reason to assume that states are going to try to crack every single majority-minority district. And the reason
the illustrative map showed that a map drawn without looking at race.
It's not illustrative, it's illustrative. Illustrative, Sonia.
And partisanship together would have created 2 districts. Compact in all traditional ways, it would have been District 2 and District 6 around the Baton Rouge and 2 other counties that were tied historically and otherwise. And politics, you say, not race, is what led the state not to give them another district.
So I'll say several things, Your Honor. First, I don't agree with your characterization that the illustrative maps were compact. They combined blacks in different parts of the state, just the way this court said.
No, you're talking about the last the state's chosen map.
No, I'm not.
The map,
illustrative map,
the illustrative map was better. The illustrative map, 2 and 6 were combined. But 2, even in the original map, was not all that compact.
Justice Sotomayor, as Justice Alito pointed out, I'm not disputing the compactness of the district. I agree they drew a very pretty rectangle. The problem is that in the very pretty rectangle, the blacks lived in the south and the north. And they took 2 very different groups of black people and put them together.
Well, the problem is that all of this map is that way. North and
South,
but
they did it for racial reasons, and the state did it for non-racial reasons.
Well, really, in excluding the blacks, they did it for racial reasons.
No, Your Honor, there's no argument for that. As Justice Alito pointed out, the state's maps have been pre-cleared twice by the Department of Justice. So the suggestion that the fact that the prior maps were 5-1 maps is not, there's no basis to say that that was for racial reasons. And again, West Virginia, 0 Democratic districts. There's a lot of white Democrats in West Virginia. There's just no reason to assume that because there's a large Democratic population in Louisiana that doesn't have a district, that that's a racial reason rather than a partisan reason.
If you can't separate out the 2, it's impossible.
But you can separate out the 2. You can control for party, and you can require them to draw a map that meets the political objectives. And again, and the last thing that you said earlier, that means Section 2 has no effect. That's not true. The examples I gave you earlier about areas like Harlem and in Florida where you have of the same party and of the state that controls that party, differences in the races, that's where Section 2 does work. And by the way, that was sort of in Jingles. In Jingles, there was showing that you could control for partisan effect. There was racially polarized voting even within the Democratic Party. That's where Section 2 matters, where you have a reason to think that a racial group is being treated.
You have some of that here, too. You have proof of that here.
No, you don't. What you have here is that Republicans and Democrats are different. There's no...
you have some that even white Republicans or white Democrats won't vote for black candidates.
Right, but if these were white Democrats, there's no reason to think they would have a second district. None. And so what is happening here is their argument is because these Democrats happen to be black, they get a second district. If they were all white, we all agree they wouldn't get a second district. That is literally the definition of race subordinating traditional principles.
Justice Kagan?
Mr. Milvan, just a quick, possibly digressive question. You're not contesting that if a state uses and predominantly uses race-based criteria in order to achieve partisan goals, that's
Agree. That's
impermissible.
Under Cooper in a bunch of cases.
Okay, that's all I wanted to know.
Mrs. Gorsuch?
Just a couple of questions about the practical implications that Justice Alito is touching on and some of your colleagues have as well. How do we control for state political objectives? I mean, you say, well, that's easy to do. Is it the number of incumbent seats that they want to protect? Is it the level at which they think protection is appropriate? Say, I need 55% of the population to be registered Republicans or Democrats. Do they get to say that? Does the state get to say, I not only want 5 incumbents protected, but I want them really protected? That's one example. You know, does the state have to say that when it's legislating, or can it come in later in the litigation and say that? Can a court, and I'm just spinning out a few things for you, you can just respond to them how you want. Can a court second guess those and say, those are not really the state's purposes, that they're just litigation positions? I mean, how's a court supposed to handle that? And then I've got some more for you.
So the same way this court already handles that in racial gerrymandering cases like Alexander. Yes, the state can come in with whatever their political objectives are. If they want to say it's not just a 6-1 map, it's a 6-1 map with a certain percentage because we want to make sure certain people are safe, really safe, and we're willing to tolerate a little bit more risk elsewhere, it's up to them to set what their political objectives are as long as they are race neutral. Now, can a court second guess that? Yes. If they say, look, these are our interests, and the map as drawn is inconsistent with that in a bunch of ways, a court could say we don't believe it.
Well, what if the map is consistent with it? Can I still try and disprove it?
Well,
So
no,
it wasn't really, I mean, that's what the map does, but that's not really what they were after.
So if you could try to bring an intentional discrimination case and say that it's pretextual.
How about cohesion, right? You know, you say, well, you got to segregate out members of one race or another based on their party affiliations and crossover voting and how much.
I mean, chat, I'm in heaven listening to these guys riff right now. I mean, like, it's hard not to disagree. What are they saying right here we're not disagreeing with? Absolutely fucking nothing. This is based. And yes, it sounds like Section 2's gonna be on the fucking menu, chat. Section 2 is on the fucking menu. Which is great. Which is absolutely based. Yes, it's already happening. We get in the sleep stream? Not yet, chat. Not yet. But yes, what's going to happen here when this opinion comes out?
Was this story based? Yes.
Yes, this guy's absolutely crushing it. So let's keep going here, chat. Let's keep going. Yes, Section 2 is down! My God! My God, the Indians and the minorities came in with the steel chair! My God, Harvey Dillon, send in the other Punjabis! How no? How? Just taking them out. So, yes, this would mean our 12 plus Republican. A lot more than that. That means there would be like 25 to 35, along with the redistricting. The Republicans would have like a 40-seat majority on paper alone every time. So, this is why I sub it and I'm a member. Well, thank you. I try. Yeah, more like there's going to be a gajillion, chat. Total Democrat death. That's what we're looking at here. But these guys are just riffing, and it's just like, I'm grooving, I'm vibing. Man, we're vibing. It's all about the vibe. Yeah. Let's go. Let's go. Like totes. Here we go, chat. Earl says, I am subbed to that anime guy. Well, guys should be. You should be subscribed to Brandon the anime guy. Say, where the population is going and how it can be done. Yes, we could see R240 easily. More, yeah, like it. The Republicans basically would always have a majority in the House. And, you know, that is kind of what we need. Chat, that's kind of what we need here. Take away their power and watch them squeal. Take away their power and watch them squeal, guys. And yes, guy want to show somebody some love out there. Chat, Brandon, the anime guy, out here on YouTube at Brandon, the anime guy. If you like anime, here you go. So, anyways, give Brandon a look if you're out there. Oh, the DI voting is bad. Yes, it's very bad. Very, very bad. Very bad. Very bad. The DEI districts are done.
They really won't vote for somebody of the other race, even if they're the same party. How much cohesion is enough? I mean, very rarely is it going to be that there's zero crossover voting and 100% cohesion, and vice versa. It's going to be areas of gray. And are we then into a business, perhaps, of stereotyping?
So the court's never made clear what level of cohesion is necessary. I think the right way.
That's why I'm asking you.
Right. I think the right way to think about it analytically is if the plaintiffs have an illustrative map that satisfies our first criteria, right? That they're.
No, this is another criteria.
Right. So assuming they've satisfied that, then the question is there enough black cohesiveness that they can win the district? So you would have to look to see how much black cohesion is there and how much white crossover voting is there. And if together they can predictably and safely win the district, then they've satisfied.
What's predictably and safely? I mean, those are nice qualifying words. I mean, does it have to be just 50 plus 1? Does it have to be 60? You know,
Well,
I mean,
so I
how
think-
does a judge make that decision?
I think the courts, what they've usually done is looked at how the map would have performed in prior elections. You don't just look at one because there can be.
Oh, you can run thousands of these things. I mean, we've got computers now. I mean, goodness, of course. And you're going to have data points all over the place. But a judge is going to have to draw a line. And I'm wondering how the judge draws that line.
So we have lots of concerns with how Jingles has applied over time, but this isn't one of them. This seems to have been.
Well, this will be the next problem if we go your way. That's all I'm saying.
I don't think so, Your Honor. And if your concern is, well, instead, let's just scrap Section 2 entirely.
No, I'm not asking that. That isn't my question. I'm asking, I'm listening to everything everybody is telling me. I'm asking you about your proposal.
Right, and so I guess my point is, if the concern with our proposal is that you will have to answer cohesiveness questions that require some amount of empirical showing, what's the alternative?
Okay, and I got it. It's always the bear. I'm outrunning a bear. I got it. Okay, predominance. What does that mean? I know it's throughout our case law, and I know you say it can't be compromised. Is that a but-for causation test? Is that a proximate causation test? What is it?
I don't think it's but-for. I think...
Well, but-for can't be compromised. It means it's an essential component. It wouldn't have happened but-for. Okay,
what's a but-for?
But-for. The way the court has described it as...
Is it a proximate cause?
I don't think that's the right way of thinking about it.
It's not a proximate cause. So what is it?
I think the way the court has described it is it's a factor that could not be compromised and where race-neutral principles were subordinated to it. So this case is a very easy case to analyze that because the race-neutral principles of incumbency protection were...
I'm not worried. Okay, I'm focusing on your test going forward, not this case.
So let me help you this way then. Because I think the question is when is predominance not satisfied where race is considered? I'll give you two examples.
Yeah, I mean, under our normal equal protection jurisprudence, we don't ask whether race predominated. We say you don't discriminate on the basis of race, period.
So let me give you two examples where race is considered, but under the predominance test, it wouldn't be satisfied. And that's why, for example, this court has said that the intentional creation of a majority-minority district does not alone show predominance, and we agree with them about that. So here's one example. The map drawer doesn't consider race at all, uses race-neutral principles. The computer spits out two maps that are totally equivalent. To pick between them, they say, okay, we'll use the one that has a majority.
But that gives rise to an inference of intentional discrimination. There's no other explanation that can be provided in your hypothetical. That's intentional discrimination. That's not predominance. That's choosing on the basis of race.
Again, neither of this court's formulations of predominance are met on that fact pattern. You can't say that race-neutral principles were subordinated. They weren't. And you can't say that the race was non-negotiable. It wasn't. So that's one example. Another example would be if you use race-neutral principles and the best map happens to be a majority-minority district. And then someone tries to say, don't draw that map, draw a different map for some other reason. And they say, no, we don't want to do that. We don't want to get rid of a black district.
That's intentional as well. Okay.
Again, I agree with you. My whole point is what this court has said again and again and again.
Oh, I know what it said. I just don't know what it means.
I think it means exactly what I'm saying, that it's not enough for it to be intent. Okay. It has to be that race-neutral principles are subordinated to race.
Thank you.
Justice Kavanaugh?
Well, I'm going to pick up right there because I had a lot of questions about your use of the word predominance as well, which the amicus briefs on your side say that word has been hopeless, I think, in trying to figure out what it means. What I've understood it to mean over time in the jurisprudence in this area is that race does not predominate if the district, even though drawn based on race, is reasonably configured and compact. Is that what you think?
Yes and no, right? So
that's not
wow.
I know. And so here's the issue. This court has recognized the test is whether race-neutral principles are subordinated to race. If you don't comply with traditional principles, then clearly you have subordination. But what this court held in cases like Bethune Hill and Cooper, and we agree with that, is if you just are dead set on drawing a 55% black district, but you manage to do it in a way that's consistent with traditional principles, that is still racial subordination. But here's the really important point for this case. We are not arguing, absolutely not arguing, what Alabama argued in Milligan, which is that the plaintiffs can't consider race, and that the plaintiffs can't have 55%.
I understand that.
And what does matter...
But it seems like your position is you can use, the state can use race a little bit.
If we're talking about the state
acting... It's kind of like the Bakke kind of thing. It's a race...
yes, if you're talking about if you're talking about the state acting in the first instance solely apart from Section 2, yes, our position and this court's position has been you can consider race, and the reason why is because redistricting is a complicated, multi-factor inquiry where lots of the permissible factors highly correlate to race, and if you don't have standard-like predominance, as this court recognized in Alexandria, every partisan gerrymander case will become a racial gerrymander case because they will always come in and say, aha, you must have...
But where it predominates, I'm repeating myself now, is where the district becomes not compact, not reasonably configured?
That is one way it becomes race doesn't predominate. The other way is if they just set out to say, I'm going to draw a 55% black district, and then they backfill from there. Because
that's race predominant.
Exactly.
Yeah.
But importantly for our purposes, in a Section 2 case, when we say that race can't predominate in at step 1 of Jingles, we are not focused on what the plaintiffs do. The plaintiffs can absolutely consider race.
I got that.
The court has to conclude that their map is better than the state's map. And then you avoid predominance.
I got that. Okay, so then what I viewed as the real innovation of your brief that we have not considered before, as you point out, is the material on page 25, the political objectives. Yes. And that strikes me as new, but also new because we haven't considered it before.
So I think that's right. I don't think this court has ever squarely considered it. I think part of the reason the court is...
What's the rationale for why it's consistent for what we have allowed before?
Because it is another traditional race-neutral principle. It is one that hasn't been urged as frequently, in part because it was unclear whether partisan gerrymandering...
Because of Rucho. I mean, pre-Rucho.
Right, pre-Rucho. But post-Rucho, it is totally clear that that is a permissible criteria. Indeed, in Rucho, the court described it as ignoring the good faith inference that the legislatures do to not consider their political objectives.
Got it. And is it also, though, part of constitutional avoidance?
Yes, again, because...
So there are two things. It hasn't been considered before, and it avoids constitutional problems if we fold page 25.
That's absolutely right. Again, I think one thing to remember here is Jingles was written in 1985. It was 10 years before this court wrote Shaw and Miller and all the predominance cases. There's just no way Jingles would have ever been written the way it was if it was decided after those cases. Okay. That is an intervening change in law that has created constitutional issues, and I think the court should modify Jingles to reflect that.
Got it. Two more, sorry. Do you agree with Louisiana on the Constitution?
In part, but not entirely.
Can you explain that?
Yeah, so we don't think that it is unconstitutional for Congress to have any results test, or that the current results test can't survive if it's construed the way we've proposed.
What if it were not construed the way you want it to be construed? What is your position on the temporal point?
So if it was construed differently than we proposed, we do think it's unconstitutional, both because of the temporal point and because of its scope just to begin with. Right?
To be clear, you're not saying Section 2 is unconstitutional. Section 2, as applied to redistricting to the extent it requires the intentional use of race to create districts, if there's no change in Jingles, that's your position.
I agree with all that, except instead of the word intentional, I would say use the word predominant. But with that caveat, yes.
Yes, got that. Okay, last, this is picking up on Justice Gorsuch. I think your Harlem hypo is very challenging because, I mean, you get into elections and you're microanalyzing the data. White Democrats and black Democrats are not necessarily, there's going to be a lot of times differences in that, and you say that triggers the finding of polarization, correct?
Yeah, if there is...
I mean, how big a difference does that have to be?
Again, I think the right way...
It's like 10-point difference?
I think the right way of thinking about it is if you start with their step one, which is what would the map look like if they'd done it on race-neutral grounds, and then say, is there enough polarization that the minority group who would have been in that district could have won, then they can satisfy steps 1 and 2.
Thank you.
If there's one last point I can make, Your Honor, which you had asked a question earlier about the practical consequences of our position. I just do want to emphasize one thing about that, which is if you look at Congress today, there are roughly 60 black representatives. If you look at the districts, there are only 15 majority black districts. So even if we're not even urging Section 2 to be limited.
Boom. That is a very big point. You're not changing much. Also, the black people are only 13% of the population. They have far more representation in the Senate and in the House than they're entitled to based on a statistical analysis. So yes, that is also a very good point.
But even if you eliminated Section 2 entirely, fully 75% of the black congressmen in this country are in districts that are not protected by Section 2. So it is simply not the case that adopting any of the positions on this side, let alone our position.
Just to be fair, they're not arguing for eliminating Section 2 entirely. I think they would disagree with that characterization.
But under any view of it, none of these positions is going to lead to there being no black representation in Congress or anything remotely approaching that.
Thank you, Counsel. Justice Barrett?
Mr. Muthan, I have one hopefully very straightforward question. It's really just to clarify. You've said, and you said just now to Justice Kavanaugh, and I take this to be in your brief too, that your position would require a modification of Jingles. Is that necessarily true? Is there a way to say it's a clarification of Jingles? I mean, Jingles is a 40-year-old precedent. So big ask to change it.
Yeah. So most of what we are urging, I think, could be described as a clarification. So we have 3 key points in our brief. One is about how you do recently configured. The second is about how you do racially polarized voting. And the third is how you do the totality of circumstances inquiry. The last 2, I think, can fairly be described as a clarification because the court has never really grappled with exactly how the totality works, and it has expressly left open the question of racially polarized voting. As to the first part, the reasonably configured, most of what we're saying is consistent with most of this court's cases, but after Milligan, I do have to acknowledge that that aspect of what we're urging, that it's not enough that it be reasonably equivalent, that the plaintiff's map has to be superior, that is undoubtedly a modification. But I would say it is no greater of a modification than, for example, what this court did in Kaiser when it retained our, but tweaked it in various ways. So I certainly think it's consistent with stare decisis.
Okay, thank you.
Justice Barrett?
That was tweaking.
Sorry, Justice Jackson.
Sorry. The plaintiff's map has to be superior in your view under this new part, insofar as it uses race-neutral criteria. Is that what you mean?
Yes.
And that's what was asked for by Alabama. And so you'd be saying that that would require a change to what we said.
No, Alabama didn't argue that. The problem with what Alabama argued is Alabama basically said the plaintiffs had to come up in court and without considering race at all, somehow magically show up with a 50% district. We're not arguing that. It didn't make much sense, so it's not surprising.
Oh, I thought they were saying you had to have race neutral drawing. That was the whole thing about the computers.
No, so they had some weird thing about computers, which again,
No,
is not what we're arguing.
but it's crucial to this point. Their weird thing about computers was you have to demonstrate as the plaintiff that you have a race neutral map, and that's what you're saying right now.
It's a very different thing. Yes, they both use the word race neutral, but what Alabama did was something about computers that I frankly don't understand. What we are arguing is simply under the state's own principles,
right,
their map has to be better. That I do understand.
All right, and then my final question, it just goes to that point, because I'm struck by your the degree to which your analysis relies on the states departing from traditional principles. You say you get to Section 2 when they, Section 2 violation when they do that. And I guess I just wonder why that doesn't leave us in a position where you really cannot remedy the effects of race discrimination operating in a district based on past discriminatory choices. In other words, you're still bringing an intent because you're saying you have to intentionally depart from your traditional principles on the basis of race, and that's what's going to trigger Section 2. And I have, for example, the Louisiana historian's brief, where it talks about how the reason why you have blacks in different places is because the residential patterns in the state are still reflective of where enslaved communities lived along this particular river system. And that residential segregation, along with disparities in political power, economic status, health outcomes, all of these things are existent today because they reflect institutional choices that are traceable to Jim Crow and reproduced through contemporary practices. That last part is a quote from them. So I appreciate that you want to say when the state comes with their new map, we have to look at the extent to which in drawing it, they have departed from traditional principles on racial grounds. What I'm suggesting is what do we do with the situation in which the state keeps presenting the same map? They're not departing, their map looks fine, but because of all of these race-based effects, because of the...
God, listening to her makes me fucking hurt my head. After listening to the other justices talk, she is so fucking stupid.
History of Jim Crow, which I appreciate happened a long time ago, but I'm positing, and Jingles allows for us to see where those effects are still occurring. I hear your test not allowing us to solve for that problem when the state is continuing to present the same map under circumstances in which people are not actually being able to have equal electoral opportunity.
So I guess I'll say three things about that, Your Honor. The first is, again, our position it does not require intent. I agree that at step one, we're saying you have to consider race-neutral principles, but if they've departed from that, we think you could find liability based on the effect without making a finding that they did it for intentional discriminatory reasons. Now, second, you pointed to the fact that it's possible that these effects stem from long distance.
Can I just ask you, why do they have to depart? What if they just keep on doing the same thing? They're not changing the map. I thought Section 2's whole point was that you gotta offer a remedy. You gotta have a remedy where this...
Because they don't think it's wrong. They think the court is wrong.
...thing is happening. So the well-intentioned state with no intent to discriminate says, the census has changed, this is where people live, but we're just gonna provide our same map. And if we can determine that that map, under those circumstances, is not providing for electoral opportunity, regardless of whether they've departed from traditional principles, I thought you had to solve for that.
And I guess our point is you don't.
You don't. It's only where they depart from traditional principles.
It's only where you could say that it's either intentionally or likely intentionally.
So intent does come in.
You don't have to prove it by a preponderance of the evidence.
I see.
It's any other results test.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Ms. Nelson.
28 months ago, this court made it lucidly clear that Section 2 is constitutional and that there needs not be a race-neutral map that is presented as part of the illustrative maps. Many questions that are presented by my opponents on the other side have been asked and answered in Milligan. What is also clear is that Louisiana is emblematic of the ongoing need for Section 2. For example, we're talking about how close this may come to intent or results. If we look simply at the evidence here in Louisiana, we see that Louisiana had shifting justifications for its map whenever it was presented with a map that met or beat its criteria and gave Black voters an equal opportunity to participate in the process. It rejected those maps. The court in Robinson also relied on the fact that there has never been a Black candidate elected on a statewide basis. Even when white Democrats won an election in 2019, Black Democrats lost. My opponents here would like to make this a partisan issue because they believe the case law will enable their case to prevail, but it does not. This is about race. Section 2 and the Voting Rights Act is laser focused on eliminating racial discrimination from our electoral process, regardless of party. And if we look at many of the Black Congress people who were elected, they came out of Section 2 opportunity districts. They don't have to be majority minority districts. Many of them are crossover districts. And so if we remove Section 2, we also recognize that there will likely be a resurgence of discrimination because Section 2 plays a deterrent effect. States are drawing maps with Section 2 in mind. In fact, Local Rule 21 in Louisiana says that the state must comply with Section 2. The fact that HB 1, which was the original map, was pre-cleared by the Department of Justice means very little. Retrogression is an entirely different standard from what Section 2 is looking at. Retrogression means the state of Louisiana cannot go backwards. Section 2 is talking about whether there is active discrimination right now preventing the additional opportunities for Black voters who meet all of the Jingles preconditions.
You can't go backwards, meaning we always have to have 2 districts now? What happens if things change? We always have to have, notice that's how she's couching this. We always have to have 2. Minimum. I'll tell you when we're done.
To have an equal opportunity to participate in the process. Requiring plaintiffs to control for party is helpful if that evidence exists, and it did to some extent in Robinson, where we put on evidence about Democratic elections and the preferences of white voters that still preferred white Democrats over Black Democrats, but that is not the only question. If that evidence is available, and I will remind the court it's not often available if there aren't primary elections or if we are looking at more down ballot elections, not just the congressional elections at issue here, that evidence is useful, but if there is significant racially polarized voting, that has already been shown to be probative of intentional of discrimination that comes very close to intentional discrimination. What Congress did in Section 2 was strike a very careful balance of using factors like white re-register, like the Zimmer factors, to bring us as close to a finding of intent without making the full accusation and without requiring that conclusion on the part of courts. So we should not downplay, as my opponents have, the robust nature and exacting requirements of a Jingles test, and also remind ourselves that the City of Rome in 1980 made very clear that Congress can address effects beyond what the 15th Amendment requires. I'll close by saying that in Bush v. Vera, this court said that it must be particularly concerned about changing its decisions or rejecting stare decisis in cases that involve a sensitive political context like this one. That calls the court's legitimacy into question in a unique way. My opponents here have not done the labor of showing that precedent should be overturned. They haven't addressed Janus, they haven't addressed Ramos. They've simply said that we should overturn or tweak the precedent that governs Section 2, and I would say that there's no record to support that in this case, and this court would be remiss to not require that if it is entertaining any significant modifications of Section 2. Any further neutering of Section 2 would resurrect the 15th Amendment as a mere parchment promise, and we ask the court to remand. Thank you.
Thank you, counsel.
So there you go, chat. That's it. Whew. I mean, guys, thank you for sticking around for that. But I mean, there you go. Yeah. How many Native American districts are there? Yes. Robust. Well, I don't think Section 2 is robust to handle Uncle Clarence, but yes. I mean, whoo, buddy. That was very interesting. Wasn't that very interesting to hear how the arguments made there? Ty says, are we equal yet? I don't know. She'll tell you when it's there. How will you know? Don't worry, she'll tell you. More Grayson says, how's the court been taking this? Minimum 5-4, Section 2 is going down in flames. I think actually based on the way Roberts was initially, it'll probably be 6-3. And I bet even Kagan goes along with some parts. So Clyde had an underwater welding class. No, I had to go take a leak. So the town was, yeah, they were still found in violation of the Voting Rights Act. Yeah, but we'll see. We'll see, chat. We'll see. Yes, if black people don't win, obviously it's still racist. So Um. Oh, so let's catch back up on some of these things, guys, here, and we'll wrap this up tonight because I am tired. Jose for $2 says, "Are you saying Nick's sex cross is not an X?" No comment. Rando says, "My old man told me about making beer runs from LSU to Houston in the late '60s, early '70s." There's the boys are thirsty in Atlanta, and there is beer in Texarkana. That's always important to remember. My blackout resulted, the MGD blackout specifically, resulted in becoming a lawyer instead of an artist. Yeah. I remember, I don't remember because I was blacked out, but I remember, like, I ended up drinking until I blacked out, and I was back, like, I got back to my fraternity house somehow, and at the fraternity, well, at Bowling Green, you had the beds that could get lifted, you could loft them, and you could bunk them, or you could just put each bed up to, like, basically you're just below the ceiling, and then you had space underneath. You could put, like, a futon, and on the other side of the room, you could have your TV and stuff like that, just because room was at a premium. Well, I was in my fraternity house. I was in a room where we had to do that again. I was lucky enough to have, at the time, not a bigger room. And apparently I got home and I crawled up and I got up into my bed. I'm surprised I was able to do that. And I'm laying there and I'm sleeping, and all of a sudden I wake up and I just, like, lean over the edge of my bed and just fucking barf, just toss my cookies. And just bleh, and it goes right into my clothes that I had just washed. It's Friday night. And apparently I got so drunk by, like, I started drinking at like 5 on a Friday. By like 9 p.m. I was already back at the house. And this is by like 10 o'clock. I just barf right into my clothes. And I wake up in the morning and I get down off the bed and I see my clothes, my basket full of clean clothes. I think I even had folded some of them, just fucking vomit all over them. And I remember going around the house. I'm like, who the fuck threw up in my clothes? I was like fucking angry. I'm like, who the fuck did this? This isn't a fucking joke. And they're like, they're all like, I come down and find a bunch of them sitting there and they're watching TV. They're getting ready to, I think Bowling Green had a home game that day for football on Saturday. It was an afternoon game or an evening game. And they all kind of stare at me like, you did. I'm like, there's no fucking way I did. And they're like, you totally did. You leaned over and went, bleh. And so I climbed back up in my bed and I got to where I normally sleep. And I kind of got on my bed and I rolled over the edge of the bed and I looked over and I'm like, sure enough, like, I looked right fucking down on it. It's like going back to Dealey Plaza. And I was like, yeah. But that, I don't know, was that the MGD black? I think it was the MGD blackout. So, yeah. My blackout was my real first encounter with the Baldo. God, I hope not. Botto says, I attended Sotomayor's hearing in 2009. Very nice. Judy Tester says, whoa, did you see Pod Awful is on a generational run? No, but Jesse does the Lord's work over there at times. Great. Yes, we already answered this one, Gray Loner. Yes, I'm autistic. That makes me black now. It does. Amateur Iconoclast gifting 1 sub. EDW Raptor gifting 1 sub. Thank you, guys. Benjamin Lewis's Daddy Don is looking out for the doggos in Ohio. Yep. Anderson Cooper says Clarence Thomas was confirmed 34 years ago today. Yes, he was. Time flies. Torger the White says, my God! The Jeep with the steel chair! And Duck Nuck 84 says, no. It's Section 2 is down, sir! Malcolm's been a member for 18 months, says, have you considered doing an art or RON stream? I mean, I've thought about it. The thing is, you have to, like, I'd have to run the shit out of mods, and also, if I'm doing Ready or Not, really, guys, and Ready or Not's where you do, like, you basically operate as the 5-man SWAT team, I'm going to need people to play it with. So I'm going to try to, I have to get a hold of some people. Like, if we're going to do Ready or Not, it's only so much fun when you're by yourself. But we could try that one night. We could try that one night. And the neat thing is, because it's a video game, you can have guns displayed. So, but we might do that at one point coming up. But thank you for being here. 18 months. I appreciate it. Duo and Max and meme. Max would just start fucking baptizing everybody. I don't need that. Oh, I'm a cox and I'm your Hucklebear in a car. Yeah, well, we might. You got Ready or Not? All right. Well, we're going to have to do it with the full mods on, because remember, guys, Ready or Not got nerfed for consoles. They took all the growdiness out of it. So, let's see here. Eldegusto says, knew a union guy and he hated Clarence Thomas as the devil. Well, he could suffer. Earl says, also maybe some old cases you think are interesting. I mean, yeah, we could try some of those. You got Ready or Not also? I mean, yeah, like I said, we may have to work on that. Do I think there will be a 24+ shift for the R's? Well, yeah, everybody's redistricting. Ohio's going to redistrict, guys. Everybody's fucking redistricting. Indiana is going to redistrict and pick up a seat. Ohio's going to pick up maybe a seat or two. Like, everybody's just shaving off a seat here and there. Then you got Texas, which is bukkake that. So, yeah. So, but yeah, I mean, like, there could be some nights where we talk about older cases or something. I think you're talking to me here. Yeah, we could do that. Now do Illinois. Well, you have to basically kill Chicago for that. We should do hot seat, Ready or Not. You fuck up, you get kicked, and someone else joins, except for the host, of course. We might be able to do something there. Chat. Like I said, we'll have to do that one night, because I'd have to coordinate with a bunch of people. But I think we could do that one night coming up. We could do some Ready or Not. So, just don't do cooking streams. My cat's name is Sarah, and Karen says, can you review my active case in Florida? I represent myself. LOL. I mean, I'd be happy to talk about it privately with you, but I don't like doing that to people, because you may not. Let's say you do that and I bring it up, and it's one thing if everybody says, oh my gosh, you're retarded. But if I look at it, I mean, are you worried that I might be like, whoa, buddy, look at this retard? I mean, that could happen. And I don't think that's fair. I don't think that's nice. I don't want to do that. But also, I don't think it's a good idea to dox yourself if you don't have to. You don't want that. And you don't want to dox yourself if you don't have to. I would not recommend it. I hope that case about the 2020 census gets corrected. I don't think that's going to go anywhere. As much as I'd like to, they're going to say it's too late. Earl, you're saying you want me to do some stuff, something interactive? Well, we went ahead on Monday night and we worked on because I had never actually done some of the games like What the Dub and Rift Tracks. There's games where you guys will be able to, like, we could do the run well. We could participate in those. I think it'll be a lot of fun. We've got some things we're going to do here coming up. So we've got some stuff we're working on. And you guys will be able to join. And I think it'll be a lot of fun here. Had enough of alien ice cream made by Indian street feed. Oh. Did I see Trump's press conference today? No, I was busy working, sadly. Oh, I'm totally kidding, Sean. I would never do that to you. Well, I would probably just talk to you off to the side. I'd be like, well, yeah, I'd say yes or no, maybe so, how things were going. So I'd probably leave it like that. So tiny hats and racism wins on a game stream. Yes. Yes, it always works. If everybody always brings everybody to the yard. And Vodka Blood, we're going to end on this here. Vodka Blood, I hope you're doing well, says, oh my God, I thought of a new lawsuit. We turn the Outer Cape of Massachusetts for a gay district. If low-income blacks can have one, higher-income gays should have one. Well, why is it got to be like the Cape? Isn't that kind of stereotypical? Like, yeah, it'd be worth trying. It would be worth trying. Is Mindset doing okay? All I know is I saw on the farm somebody recapped it. I'm going to reach out to him. I think Andrew's all right. Who knows? We'll check on him. I'll check on him. So, Ohio has a gay district. Well, I mean, So, all right, chat. That is it for tonight, guys. Thank you, guys. Almost 4 hours. We got her done. Let's see here. Oof. What happened to Mindset? I don't know. People are making it sound like he lost his mind during a stream or something. I don't know. I haven't had a chance to look at it, so I'm assuming Mindset's okay. He's pretty solid. So, but anyways, I'll take a look at it. But anyways, I'm going to check. Like, I don't know. I'll just see what he's up to, but I'm assuming he's okay. I must foam. Yes. The foam must flow. All right, chat. With that being said, I will let you guys go for tonight. Remember, tomorrow night is the Thursday night show because it will be on Thursday. We got a lot to talk about, chat. We got a lot to talk about. Be a lot of fun stuff there. I mean, we're going to be getting into Alex Jones, Comey's indictment. You know, John Bolton might be getting indicted here, it looks like, by the end of the week. Alec Baldwin probably got a DUI, even though it totally wasn't a DUI. Even though almost all single-car accidents, there's a high chance of a DUI occurring. We're going to go over the guy allegedly who committed the arson in L.A. for the Palisades fire. Obviously, Aaron's jail issues. Then there's also an issue of a guy who brought a forced reset trigger, an FRT, to a range in Virginia, and the people at the range called the police, and then the guy ended up getting arrested. There's a lot more to it, but we're going to cover that. I think it'll be fun. There's a lot to do. Bengals are on tomorrow. You might miss. Wait, are you fucking kidding me that you're a Bengals fan? Might. You what, mate? You're a Bengals fan? Do you have a license to support a shitty NFL team like that? So. Oh, no, chat. Anyways, good night, you guys. I will see you next time. And just remember, until tomorrow at the very least, just because you did it does not mean you're guilty. Unless you're trying to gerrymander more black districts, then you're guilty. And you're going to lose. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking.
No, and we'll talk about the difference. We'll talk about the difference tomorrow.
Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy?